S.K. Das, sir. And sir, on the behalf of ICSI IIP, I welcome you for today's session. And the topic of discussion for today is liability of personal guarantors under IBC. Sir is working as a deputy journal manager in IBBI, heading in the team of CIRP division and individual insolvency division of both. He is looking after the policy research in the corporate insolvency process and the implementation of individual insolvency provision of Insolvency and Bankruptcy Code. Sir is an MBA with specialization in finance and a certified associate of Indian Institute of Bankers. He has more than 20 years of experience in banking sector and has served in diverse capacities in multiple banking and financial institutes in India as well as abroad. Sir is also a professional Grade B commercial mediator certified by Ministry of Corporate Affairs, Government of India. His area of expertise include analyzing banking practice and procedure and is actively involved in spreading awareness about the provision of code through his constant research and publication. Now I would request sir to please share some highlights on the subject.
Thank you. Am I audible?
Yes, sir, you are audible.
Yes, sir. Very much.
Thank you. Namaskar, sabhi ko. Good afternoon, Mr. Anand Sonbhadra ji, insolvency professionals, and the learned speaker for the day, who will be enlightening us today, and all the participants, all the officers from the ICSI IPA as well as the IBBI, and all the distinguished participants who have joined us online, which are more than 100 in a day, which is in the far end of the year. And all are in the jubilant mode. All want to enjoy this year end, but still in the very odd time we are joining. And that's thank you very much to all of you. And it shows the importance of the topic, importance of this legislation in the Indian economy. Once again, a very good afternoon. And again, welcome, as already told by that this is the second series of this kind of workshop on the perspectives of the IBC and array. And on the last day, the topic is a very important topic, which is very relevant and which is a very sought after topic of the current scenario, the liability of the personal guarantor under the IBC. So we'll touch upon, I'll very hard give in 10 minutes, I will try to complete, just give the inputs, then we'll listen to Sushanta ji with his expertise. So you all are, those who are joined us together here, all are one of the part of the very critical pillars of the IBC. We know that there are the 4 pillars of the IBC and one of them is the insolvency professionals. So I must say that all of you may be working or a few of them are on the line to work or to join this profession. Today, when we are talking in the December 2022, so we know that we have almost completed 6 years. This IBC journey has almost completed 6 years. So in these 6 years, this legislation has faced many ups and downs, less downs. And a little background, like the CIRP processes or the corporate processes, those who have been notified when the IBC has come into effect within the 2 to 3 months time, these processes have been notified from the 1st December 2016. However, the part 3, which is giving the insolvency and the bankruptcy process for the individuals and the partnership firms, they came into effect in the December 2019. And I am talking about the individuals and the partnership firms. Part of the individuals, that is the, we know that section 2, E, F, and G. So out of the 3 parts, only the provisions related to the personal guarantors have come into effect in the 2019. As the question, the topic of the subject, the liability of the personal guarantor, it must comes to the mind how the personal guarantor is liable under the provisions of the code. So if we recall, or all we know that section 128 of the Indian Contract Act, that is 1872. So that provides this provision which are personal guarantors or the actually guarantors are the liable. So the liability of the guarantor or the surety is the coextensive with the principal borrower. It is very well known fact to all of us. So when the guarantee is invoked and the guarantee is not paid, then the guarantor becomes the liable. And the creditor, they have the every rights to either go for the principal borrower first, or they can go to the personal guarantor or the guarantor first, or they can go to the simultaneously. So the law is well laid down, and this has been by many jurisprudence. We know many jurisprudence. The one of the most famous, maybe the when we regularly quote, is the SBI versus V. Ramakrishna. The similar thing has been also provided in the court. The personal guarantor that has been defined in the code under section 5 subsection 22, which provides that who is the surety in a contract of a guarantee to a corporate debtor. If an individual, son, he will be called as the personal guarantor. Similarly, the personal guarantor rules also define the guarantor, personal guarantors rule 3 clause E. So that speaks about the debtor who is a personal guarantor debtor, and in respect of whom a guarantee has been invoked by the creditor and it remains unpaid. Here is the clause. The unpaid means whether it is a fully unpaid or partially paid and partially unpaid. So in the both the scenarios, whether it is fully paid or partly paid, if it remain unpaid to a little extent also, then these provisions will be applicable to such personal guarantors. Next, the question which comes to in our mind is under what circumstances this guarantee can be invoked. I told section 126 of the Indian Contract Act. So in accordance with these provisions, these guarantees are invoked when the principal borrower defaults in making the payment. The creditor has every right to invoke the guarantee, and when the guarantee has not been paid, then the personal guarantor is liable to the pay, and the creditor can initiate the insolvency resolution process under the provisions of the code. We all know, as I was just telling, that the provisions of this insolvency resolution with respect to the personal guarantee of the corporate debtors come into effect from November, coming to effect from the 1st December 2019. Since then, there was many legal hurdles or legal challenges are being faced, be it in the NCLT or the appeals are filed before the NCLAT, the appellate authority. Various writ petitions, various means more than hundreds of writ petitions have been filed before various high courts, and writ petitions are also filed in the Supreme Court. Then unilaterally in the Supreme Court, in the Landmark judgment, you all know that Kumar versus Union of India, when the judgment was passed by the Supreme Court, a notification which brought into the effect of the personal guarantors provisions, it upheld the legal validity of those provisions, that notification which are challenged. And simultaneously in the said judgment, Supreme Court also upheld that once the resolution plan has been approved in the CIRP process, that will not discharge the liability of the guarantor. So those things also come in that litigation matter. So once we thought it has been settled, so few cases have been filed, few cases have been admitted under section 94 as well as the 95 of the code. Later on, again, many challenges are now being again filed before various high courts, be it Karnataka, Madhya Pradesh, Kerala, many in almost all high courts across the India, writ petitions are filed. Again, the writ petitions are also floated in the Supreme Court, which is led by again the Anil Ambani. So Anil Ambani matter, and now it will reach its finality. Hearings are going on in the Supreme Court, so anytime we can expect it's the finality, so that it can be settled. So we are just going through these writ petitions when it was challenged by various parties. The main one contention is against our resolution, our IP's insolvency professionals, or in this process we are calling it the resolution professionals. So main challenges is the resolution professionals are vested with additional or abundant powers under the code, which gives in the section 99, where the RP is supposed to prepare a report and recommends for the admission or rejection of the application. That will be definitely Sonbhadraji will take it further on more. So these are the major challenge, and the next challenge is the Article 14. They are not getting the principle of natural justice, violation of Article 14, and one more the main thing in almost all the writ petitions are the personal guarantors are not getting hard. There is no opportunity till it is admitted under or rejected. The application is admitted or rejected under section 100. So when I am talking about this, some last 3 years since the provisions have come into effect, we may have come across many jurisprudence. I will just like a few, like 3 jurisprudence. One which is very popular among all of us, which has been quoted in almost all the NCLT judgments. That is the Ravi Ajit Kulkarni judgment, where the concept of limited notice to the personal guarantors has been provided. So almost all the judgments now this has been given. So it tells us that limited notice can be given to the personal guarantors, and the final stage of hearing from the personal guarantors, NCLT or the adjudicating authority, only at the time of admission or rejection under section 100. These things again, same things are again upheld by many high courts. To like a few, the Karnataka High Court in the I think Babu Edhamangi case. Kerala High Court also upheld the same thing in the John Jacharia case. Similarly, one more judgment what I recall is the Sapurji Palonji Finance versus one Rekha Singh. So in that matter, what happened now? This financial service provider, which has been also came into under the provision of the code under section 227, which has been notified during the same time when the personal guarantors provisions were notified. So whether any personal guarantors to a financial institution like one NBFC, so whether the insolvency resolution process can be initiated against that or not. So the NCLT held, yes, they can also be initiation, IRP process can be initiated against the personal guarantor of an NBFC. However, in that particular matter, that NBFC was not qualifying under that section 227, which talks about the assets, the NBFC should have been the 500 crore and above. So when that NBFC was having less than, so at that time, that process was declined. Similarly, one more thing was we may recall the death, in case of a death of a personal guarantor, whether the creditors can proceed against the legal heirs of the personal guarantor or not. So that is in the Alchemist Asset Reconstruction Company versus Deepak Puri. In that, NCLT held that IAP cannot be initiated against the legal heirs of a personal guarantor where the personal guarantor has died. But however, the option is open that the creditor can initiate bankruptcy process against the legal heirs in such a cases. So before ending, just I would like to give a data how many cases have been admitted, because this is an opportune forum for me also to address all the IPs and request the IPs to share the data where they have been appointed as the RP in the personal guarantor matters, so that we can strengthen our database. So as of September 2022, which have been published in our quarterly newsletter, we have, at that time, as per our information, there is 1,400 cases have been filed. So after that 1,400 cases, around 71 cases have been withdrawn, and around 123 cases have been admitted also. So out of these 123 cases, some have been closed. Some have been closed means in 2 cases, important. One, NCLT Guwahati is the first cases where 2 cases have been, repayment plan has been approved by the creditor and followed by the NCLT. So there, then some cases repayment plan has not been, repayment plan has been rejected by the creditors. Some cases, 2 cases were withdrawn after the admission. And the most important thing is the repayment plan not submitted. Section 105 tells about the submission of the repayment plan by the personal guarantor. The personal guarantor has to file the repayment plan. But we are observing that many cases repayment plans are not filed. So RPs are filing the application before the adjudicating authority. In two cases, the NCLT has uh, closed the IRP process and have given the opportunity to the creditor or the debtor, they can file the bankruptcy process. So I will be requesting all my IP friends here, they should take this seriously. That means they should inform the personal guarantor if you are not filing or submitting the repayment plan, the this IRP opportunity what we have been given, your insolvency resolution, that start. So when the bankruptcy process is starting, that is a much, I can tell, much harsher than the insolvency process, because all the assets, all the estate of the bankruptcy, bankrupt at that time will be the bankruptcy estate. So my thinking will be there should be at least submitting the repayment plan. They should try for the approval of the repayment plan, and there's so that it should not land into the bankruptcy court. In the data front, I am actually feeling very happy to note that the performance of the IBC, which has been noted by the RBI's latest trends and progress report, which was published just 2 days back. So, which speaks about the recovery of NPA, the NPA. So, it talks about the recovery of NPA, which was in the last financial year was 14%. This has been in the during this FY22, it has been improved to 18.4%. So with the good recovery and the less slippages, so the gross NPA of the scheduled commercial bank also now stood in the September 2022 is fixed at it is only just 5%, which was around 9%, 10% in 17-18. So it is a very good improvement, and definitely the contribution of IB's recovery and the stand of NPA is well recognized in this trends and progress report, which of course it is a good support from all of you for that the performance of IBC has been recognized. So which talks about the report is talks about the four methods of recovery for the banks. One and the major contributor is the IBC, which is contributing in the during the last financial year. 53% of the recovery are made through the IBC road, followed by 30%, around 30% through surface AE, 13% through DIT, and this also highlighted the recovery made by the banks through IBC, which is talking about the realization of 201% of the liquidation value has been realized through the IBC mode when the applications are initiated by the financial creditors. So all these success are not belongs to us; it belongs to all of you, all my the IP fraternities, and I still we hope more and more success to come in the future, and this definitely depends on you, your commitment, quality of your work, and your conduct during the profession or the process you are holding. So because you hold the key of the fate of the firm, you hold the key, the success, of the firms, and you hold the key for the value maximization for the CD as well as all the stakeholders. So we here in the board, Insolvency Bankruptcy Board of India, as well as all the IPS, obviously we are also responsible for that, for your development, for your development in this knowledge base or whatever. It will be ongoing, of course. So that is our responsible, and for which I think the ICSA IPA has come out organized, so we can share the knowledges for the benefit of all. We all know this is a rapidly evolving nature of IBC. As just I was talking about the jurisprudence development, I was just giving this some thoughts on the personal guarantors part. Jurisprudence of the CIRP, it is a huge. So as today's we will be speaking about the personal guarantors, so I have limited my mind. I will not take further much time, and I will ask my IP friend Sonbhadraji to take over the sessions for the last 3 to 4 hours. So all of us should be amply benefited from that. And I wish all of you this 3 to 4 hours a happy learning period. And I thank once again ICSI IIP for giving me this opportunity to share my thoughts, share the thought of the IBBI among all my IP fraternities, and welcome you once again. Thank you.
Thank you so much, sir, for sharing your expertise and highlights on the subject. It was indeed a pleasure listening to you. Thank you so much on the behalf of entire team. And now, moving forward with the session, I would like to introduce Anand Sonbhadra, sir. He will be taking up the today's session. Sir is a chartered accountant and a practicing insolvency professional. He holds the position of senior designated partner at AAA Insolvency, largest IPE in the country, and assisting other partners in CIRP and liquidation cases. Sir holds over 30 years of experience in strategy structuring, mergers and acquisition, providing value through development of business with sustainable revenue and profit-based models, exposure to fundraising from venture capitalists and private equity investors. Sir has also been a speaker in our institute. Sir, we welcome you on the behalf of ICSI and IBBI. Now, I would request Sir to please start with the session.
Thank you so much. Am I clearly audible?
Yes, sir. Yes, sir.
Thank you so much for giving me this opportunity to share my thought. This is a process of learning for all of us. I am part of the IP fraternity, and alike all the participants today, we will learn together. I'll share my knowledge. And before I begin the session, I would like to profusely thank Mr. Sushanta Das. Sir, you have given a very, very good view and the data. Many of us may not be aware of the data. And I must appreciate your sharing the court cases, etc., which really sets the mood for the day in terms of where we learn and how much we learn, what are the set precedences, where the law is settling, or which particular case would be viewed differently and would cause problems like we are seeing in the CRP, the Rainbow Papers case, which is unsettling a lot of settled issues that we have seen in the CRP zone. So what I intend to do, thank you so much, sir, for your kind and enlightening words. To begin with the session, I think I have split this session into two parts. First part is trying to discover or derive the liability of personal guarantors, as amply demonstrated in the data shared by Das sir, that there are very few cases which have actually seen the end of the light here. 2, 3, 4 cases where repayment plans have been approved and the insolvency resolution of the PG has seen end of the day light. Most of them today, to best recall of my experience and the court cases that I've seen, in the Gurmeet Sodhi case, which is where the writ petition has been filed under Article 14, challenging the constitutionality or natural justice for the PGs, most of the cases are getting clubbed, or the PGs are quoting that, and in NCLT and NCLAT that I've seen, the dates are sine die adjourn and not being taken to conclusion till the time Supreme Court delivers on this. So what we will try and do is first part, let's run through the insolvency and bankruptcy process quickly to understand the nuances, as well as discover what stages, what liabilities, and how we go through that. And the second part, we will discuss the latest cases. It's not an accumulation of all the judgments which have been given on this topic, but most of the judgments that I could lay my hand for the year 2022, I'll try and discuss that. So we will split that. into part B. We will keep that into part B. And I'll start with start sharing a presentation and keep the flow there. And then at the end, we will see some question answer or try and, answers queries or discuss them and collectively find answers to the queries that arise. Okay. Can you see is my screen visible now?
Yes, sir.
Good. So the whole process on the inclusion of the personal guarantor started with the 2019. Just a moment. The flow of presentation is that part A, as I already explained, we will develop an understanding through the law that is there, and then part B will take the latest cases that I've seen. It started with the notification on insolvency resolution process for personal guarantors to corporate loans, etc. And this notification number SO 4126E dated 15th November, which is applicable with effect from 1st of December. What came into force was that in the section 2E, the applicability of IBC was assured, where personal guarantors to the corporate debtors were included. And with that, section 94 to 187, both the section inclusive, were also notified. What does it say? In addition to that, it also notified the power for making rule, etc. for IBBI and regulations under different sections of 240, subclauses of 240 were notified, and certain amendments to recovery of debts due to banks and financial institutions, etc. were notified, including government's requirement to set up DRT and DRATs, because we will see as we progress in what cases the insolvency proceeding would go to DRT, in what cases the insolvency proceeding will remain with NCLT or they'll go to NCLT. Now let's start with, just a moment. Let's start with the definition of personal guarantor. What does it say? This is a debtor. I'm having some little bit of problem. Just a moment on the screen. Just give me 30 seconds. Yeah. Now let's start with the definition of personal guarantor. Defined in rules is a debtor who's a personal guarantor to a corporate debtor and respect of whom guarantee has been invoked by creditor and remains unpaid in full or part. Just quoting what Mr. Das also said in the beginning, that two critical elements: a personal guarantor is a debtor to a corporate debtor in respect of whom corporate guarantee has been given by the personal guarantor, and that has been invoked by the creditors. And second part is followed by the invocation, that debt remains unpaid either in full or part. Then he's termed as personal guarantor. Now let's see in the same this thing, who is adjudicating authority and what is the jurisdiction there? Where CRP or liquidation proceeding of a corporate debtor is pending before NCLT, then the application for insolvency resolution or bankruptcy of the PG will go to NCLT. That's very clearly stated. And insolvency resolution process or bankruptcy of a PG of such CD will have to be filed in NCLT. If there is no proceeding against the CD and yet a personal guarantee has been invoked, or if it is pending before any other court, then the then the personal guarantor's case will go to DRT. So very clear distinction.
Here, proceeding means that CRP of the CD has to be admitted, or just even application pending is also enough?
No. See, application pending is not an admission. So if the proceedings is pending before an NCLT proceeding starts only after admission. Okay.
Simultaneous filing is also allowed, I believe.
Yeah, see, there are certain, there is no judgment on this aspect. Very clearly, we haven't come across a case where an application is pending before NCLT for the CRP of the corporate debtor, and simultaneously something is filed or an application for application for admission of insolvency resolution proceeding against the PG is filed. But my understanding is where once the case is admitted in NCLT against the CD, then even if it is where if the personal guarantor's case is in other courts also or other tribunal, it has to be transferred to NCLT. In absence of that, it will continue DRT. But where the proceedings against the CD is not initiated or it's not ongoing, then it will continue in DRT. That's a clear dictum which comes from the existing provisions. See, and how do we decide the jurisdiction of DRT? Because as far as this CRP of a CD is concerned, the jurisdiction is decided by the registered office of the CRP of the corporate debtor. But in case of individual personal guarantors, this would be decided by where the individual debtor actually and voluntarily resides or carries on the business or personally works for gain. So that is an establishment while RP, while filing is this thing, has to make and clearly say that particular DRT has the jurisdiction. It has got not with the registered office of the CD. So the criteria underlies is actually or voluntarily resides, carries on business, or works for professional gains or personal gains. Now, there could be a situation, there could be a situation, let's take NCR case, where a person may be residing in Gurgaon and he must be maybe carrying on business in Delhi. To my mind, either of the jurisdiction, the case can be filed. So the definitions, continuing with the definition of adjudicating authority, for the purpose of Section 60, NCLTs and DRTs are the adjudicating authority depending on the specifics of the case. Now it's a two-stage process. If we look at it, it's a two-stage process. The insolvency proceeding. The first is insolvency resolution process, which is elaborated from Section 94 to 120, and then the bankruptcies, and they follow in sequence. As and when an application for insolvency of a personal guarantor is admitted, it is towards the insolvency resolution process of that guarantor. If the insolvency resolution process fails prematurely, or it is no repayment plan is there, which means it fails again, then the creditors can directly file for the bankruptcy, which is contained in Section 121 to 178. Now, who can make an application for the insolvency proceeding of the personal guarantor? Who can make an application? Here, either the personal guarantor themselves under Section 94, or the creditor whose debt remains unpaid either in full or in part. The creditor can file under Section 95. Now let's look at clearly some of the nuances or the provisions for application which can be filed by the guarantor under Section 94, read with Rule 6. Okay, let's see. Forward. And then under 94, read with Rule 6, the personal guarantor can himself file, and then creditor can file again under Section 95(1). What are the key steps which is to happen if a creditor has to file this? One of the key requirements is a notice for invocation has to be given in Form B under Section 95 by the creditor to the personal guarantor. Of course, the application has to be filed in Form C of the rules, application fee of 2,000 rupees, and it can be filed jointly by one or many creditors. Joint filing is also allowed. Then the application should carry the details of proof of debt, proof of default, and evidence that the debt has not been paid within the 14 days period, which is as per the notice it has to be given. The application copy has to be served on the guarantor and the CD, of course, to whom the loan is given. And as far as possible, the application should also provide information about assets of the guarantor, immediate family, annual income, directorships, debts, excluded asset, which we'll see further what is excluded asset, what is excluded debt. But that's just to touch upon what are the details that application needs to have. Continuing with that, particular of a resolution professional, if the application is filed by RP, along with the declaration and signature of RP in the application itself. And relevant documents to be attached as a documentary evidences. And the application can be filed in electronic form which today is very much possible. All the NCLTs allow you filing in e-filing, and then of course followed by a physical submission of the documents e-filed. Now let's come to the key point of what are the assets which will not become part of the resolution proceeding. What assets are excluded? Unencumbered, which means any asset which has not been securitized or which has been not collateralized, which has not been given as a security or collateral. So unencumbered tools, books, vehicles, and other equipment as are necessary for the debtor or bankrupt, as the case may be, for his personal use for the purpose of his employment, business, or vocation. So necessary items which needs to be, which is required by the guarantor or debtor to make a living is something which will not be included, and we'll see how as we go further. Any unencumbered furniture, household equipment, and provision that are necessary for satisfying the basic domestic need of the and his immediate family. So whatever are required for meeting the basic necessity for the family or him to live is also not part of the assets which will go into as part of this estate. Any unencumbered personal ornament, however, the law has fixed a value on it of rupees 1 lakh, which cannot be parted with in accordance of religions. To one of the key, say a Mangal Sutra for a lady, or sometimes some deity's picture which may be gold plated or something, for some religious reasons that people want to keep it, and which cannot be parted with. However, that should not be exceeding in value of 1 lakh rupees. It's also not part of the bankruptcy estate or the estate of the personal guarantor which has gone into resolution. Any life insurance policy or pension plan taken for himself or for immediate family, that also is not part of the excluded. In addition to that, an unencumbered single dwelling unit owned by the debtors having following rules. Now, this could become a heated discussion matter because the values given here are what they are as per law. And somebody has a house whose value is 80 lakhs. How will you divide 80-20? That's a discussion of another day. But what the law says is a dwelling unit in urban area not exceeding value of 20 lakhs. 20 lakhs value dwelling unit in rural area of 10 lakhs. And rural area has been defined as per section 2 of the National Rural Employment Guarantee Act of 2005. And urban area is any other area than the rural area, explanation to Rule 5 of the same act, which is 2. Let's see what is excluded debt under section 79. 78 deals with, 79 we have seen, 1479 subclause 14 deals with excluded asset, and 15 deals with excluded debt. Any fine imposed by a court or tribunal that is not part of liability, that is taken while the resolution process or bankruptcy proceeding. Any liability to pay damage for negligence, nuisance, or breach of a statutory, contractual, or other legal obligation. So any award given against to pay damages for, for breach of contract, then those damages as per the award will not be part of debt. If somebody is a divorced person, or as per the orders of the court, somebody is ordered to pay maintenance to any person, then that maintenance amount or maintenance payout that has to be made will be excluded from the debts of the personal guarantor. Any student loan taken by him or her will also be, and any other debt as may be prescribed from time to time, whatever the regulations or the rules may prescribe, that those can be excluded. Let's look at, after that, to understand the whole concept, let's look at some of the key definitions. And one of them is immediate family of debtor means his spouse, dependent children, and dependent parent. So immediate family has been clearly defined. Wife or husband, dependent children, and dependent parents. And then we move to the next step, associate. So associate of a personal guarantor or debtor would be first a person who belongs to the immediate family. An immediate family is defined as per section 79(17). Or a person is associate when a person is relative. We'll see the definition of relative in a chart, who all are, considered or who are, as per law, are relative of the debtor or the relatives of spouse of the debtors. They are associate. A person who's a partner with the debtor or who's in a partnership with the debtor in business is an associate. A person who's a spouse or a relative of any person with whom the debtor is in partnership. A person who's an employer of the debtor, employee of the debtor. A person who's a trustee, in which the beneficiary of the trust includes debtor. Or terms of trust confer a power on the trustee which may be exercised for the benefit of the debtor. And a company where the debtor or debtor along with his associate own more than 50% of the share capital of the company or control the appointment of board of directors. So there is a wide coverage as far as the definition of associate is concerned. For the purpose of the section, relative with reference to any person means anyone who is related to another if they are member of a Hindu undivided family, and or one person is related to other in such a manner as may be prescribed. Now, how does one go about determination of associate? And it's very important. Now look at associate creditors. What is the position of an associate creditor? What we have seen in CRP, a related party. It's similar to that. So associate creditor would have no voting rights. There is no concept of committee of creditors in the insolvency proceeding of personal guarantors. But voting rights, creditors are there, voting remains. So anybody, as per the definition, comes to be termed as associate creditor, then there's no voting right for approval of resolution repayment plan or for approval of any resolution during bankruptcy process. So under 109, their role has been restricted, and corresponding the bankruptcy proceeding under section 135, their voting rights have been this thing. Also, any transaction with associates whether it's undervalued, preferential, extortionate, etc., they are covered from 164 onwards. They will also be treated harshly, and look back periods, we will see the look back period are given when we run through these. Now, relative, I said, let's look how exhaustive the definition of relative here is. Relative with a reference to any person means anyone who's related to another in the following manner, namely, members of a Hindu undivided family, husband, wife, father, mother, son, daughter, son's daughter and son, which is grandchildren, daughter's daughter and son, again, this thing. And it takes one more step further, grandson's daughter and son, granddaughter's daughter and son, and includes the lateral family also, brother, sister, brother's son and daughter, sister's son and daughter, father's father and mother, mother's father, maternal, paternal, grandparents, father's brothers and sister, chacha, taya, bua, mother's brother and sister, mama, mami, both sides are covered. Wherever the relation is that of a son, daughter, sister, brother, their spouses shall be included. So it's a very wide definition that the law has cast on associate and relatives. Now, what happens when an application is filed under 94 or 95? Unlike CRP, there is an interim moratorium as provided under section 94, 96 starts from the day the application, which means once you have filed the application and a diary number is allotted to you, that becomes a valid application. And from the date of that diary number generation or the date of the application acceptance with the registry of tribunals, there is an interim moratorium which comes into play. And what does it entail? We will see that. And this interim moratorium will cease. We will see the moratoriums as we go ahead in the presentation. Interim moratorium runs from the day the application is filed till the date the application is admitted or rejected. Okay, during the interim moratorium period, just like 14.1, any legal pending action or proceeding in respect of any debt shall be deemed to have been stayed. Any debt. We will see this connotation when we go to case laws also. We will see how the tribunals and high courts have given judgment on this and how it is settled. But it says pending action or proceeding in respect of any debt of the personal guarantor has to be stayed. The creditor shall not initiate any legal action for any kind of recovery or proceeding in respect of any debt of the personal guarantor. Okay, so the interim moratorium. One more thing, if any, suppose for a personal guarantor, if the bank had started surfacing proceedings against a collateral asset, the day an application under 94 or 95 is filed, which means a diary number is allotted to it, that surfacing proceeding cannot be further taken, or the asset, whether it's symbolic possession or actual possession of that asset, cannot be taken by the creditor who initiated the recovery proceeding under surfacing. So legal proceeding has to stop there. Now let's look at the admittance of application, appointment of resolution professional, these section 97 deals with that. So NCLT will do, deal with the application under Rule 2026 of the NCLT rules, and DRT will do under it Rule 3 and Regulation 3, 4, 5, and 11 of the Debt Recovery Tribunal Regulation. If a resolution professional is not filing an application, which means he's been nominated, his consent is taken, his signature is there on the application, if that's not there, then adjudicating authority will appoint a resolution professional if it is not filed by him from the database. What is happening? So from the empaneled set of IPs submitted by IBBI to the tribunal, the adjudicating authority will go ahead and appoint a resolution professional. And if an application is filed by RP, then after verification of the disciplinary proceeding against that RP, if it is not there, then also the appointment will be done by resolution professional, of the resolution professional. So two things here. An RP, there is no concept of IRP. An RP is appointed if he files an application, then to check verification of the disciplinary proceeding, the RP is appointed by A. If application is filed by debtor or creditor, not through a RP, then the A will go ahead and appoint a RP from its own database, shared by the board from time to time. And as a consequence of appointment, a copy of application will be given to the RP. In case, if he is filed, that copy is with him, but legally also he'll get a copy. If not, the appointee from the panel will be given a copy. Now, how would the AA deal with it? The provision of the law says, like section 7(9) application in the CRP, A will have to verify the existence of debt, disbursement of debt, and default in repayment after giving opportunity to the other party. Then they can admit and appoint resolution professional. However, if the adjudicating authority wants to reject an application either in 94 or 94, if they feel that there is an intent to defraud the creditor or the RP, then the application can be rejected, and that would make the creditor entitled to straightaway file for bankruptcy directly under section 104. Now, I will not talk about timelines because that is a settled matter now. Even though the provision says 14 days, however, its timelines have been regulation timelines have been, considered to be directory in nature. They are not mandatory. So, Honorable Supreme Court has relaxed and held that timeline is important, but not at the cost of justice. Now, who can be appointed as resolution professional here? More or less, the qualification remains same, alike CRP here, or for that matter, a liquidator. Any insolvency professional who is independent of the guarantor and his IP. And his IP, meaning the IP to which he's a partner, his partners or directors of the IP are also independent of the guarantor. They are not representing, any of them are not representing the guarantor in any role in that sense. Of course, as a matter of proprietary, the IP should not be subject to any disciplinary proceeding by the IPA or IBBI, or they should not be under any restraint order. As I earlier said, the IP partner should not represent any party in the insolvency resolution process. Now, the independent has been elaborated here. It says not an associate. Associate, we have seen the definition, so it's not an associate of the guarantor. We have seen elaborately under section 524 the meaning of the definition of related party is not a related party to the CD. Both. It's not an associate of the guarantor as well as not a related party to the CD. This too has to be seen clearly for somebody to be appointed as a resolution professional. And he should not be acting. So somebody who's a IRP or RP or a liquidator of the corporate debtor whose debt the personal guarantor's guarantee has been invoked, that RP, IRP or liquidator cannot be appointed as a resolution professional in case of the insolvency of the personal guarantor there. Now, an interesting question arises. Can partner of the same IP other than the RP of the CD be appointed as RP for personal guarantor? If you read the regulations 4A extra, it is not coming out very clearly like the one in the previous one we said, where it clearly says that IRP, RP resolution professional of the corporate debtor cannot be resolution professional of the personal guarantor's insolvency proceeding. However, it does not say. So it is, as a conservative view, one can say another partner of the IP or the RP's partner, RP of CD, his partner can become RP of the personal guarantor, but a conservative view will be avoid it. That's my personal view, that even though regulation does not explicitly says that, but one can definitely be conservative and say, if I am the RP liquidator or IRP of the corporate debtor, then none of my partners should look at being a RP of the personal guarantee. Of course, Form A would be submitted to A separately in case the application is not filed through a resolution professional. Now, the key point here is, once a resolution professional is appointed by the adjudicating authority, an onerous responsibility is bestowed on the RP to file a report. And that report should very clearly recommend whether the application for insolvency proceeding of the PG be accepted or not. So let's look at what does section 99 say. It says that within 10 days of his appointment, he has to submit or she has to submit, or now it and IPE also can be appointed as IP. So has to submit a report within 10 days. Will clearly consider acceptance or rejection of the application. Now, so it can require documents to verify additional information from creditor or anything to ensure that a clear view is taken on the status of the application for it to recommend, and also at the same time ensure that the compliance requirement under 94 or 95 is also met with, and all information is provided or not. After looking at that, then RP shall make report recommending acceptance or rejection of the application after recording reasons for acceptance or rejection. So a report has to see compliance under 9495, as well as record the reasons for acceptance or rejections. Now, certain other key points is, if the debt is registered with IU, then the debtor or the personal guarantor cannot dispute. Information utility, if the debt is registered with information like NESL. Once the report is ready and submitted, then the copy of the report has to be given either to debtor or to the creditor, as the case may be. And then this copy of this report is to be provided to the debtor and all the creditors, even if they are not present at the meeting as required under section 113. So while filing the report, it has to be given to either a debtor or creditor, as the case may be, whoever is filing. Along with that, file with A, and then provide a copy in the meeting. Let's look at the contents of the report of resolution professionals. Now, what are the things that under section 94 or 95 that he has to comment? Existence of debt and evidence, ensuring that the debt does not include excluded debt, existence of default and the evidence is related to that, jurisdiction of the application, whether it's correctly given or not, also needs to confirm that the debtor is not an undischarged bankrupt, it is not undergoing a fresh start process or an insolvency resolution process or a bankruptcy process. So RP has to comment and confirm on the requirements, and also taking further, there is no application that has been admitted in respect of debtor or the PG during the period of 12 months preceding the date of submission of the application. And of course, the rules and the compliance related to it is submitted in the prescribed form, all columns are filled, prescribed fees paid, then recording its acceptance or rejection of the application, also citing, recording the reasons for acceptance, and then providing a copy to the. This is how the whole report of resolution professional is to be dealt with. Now, what happens to the contents in case of what we saw was under 94, under 95, if the application is there, all the requirements has to be met with as specified under 94. Then to see, ensure that the notice of demand is served by the creditor on the guarantor in Form B of the rules. Document evidencing failure of the debtor to pay the debt within 14 days, or alternatively proof of repayment of debt by the debtor as per the demand notice. And where it has also, if an application is filed under 95, the RP may also request to the adjudicating authority for issuing instructions to conduct negotiation between debtor and creditors and for arriving at a resolution, repayment plan. Quickly running through what is resolution process cost, fee of RP, expenses incurred by RP, fee of professional appointed, any finance raised during process, or any other cost directly related to process. And it is important that the repayment plan which is drawn provides for repayment of resolution process cost in priority as per section 105. In case if the withdrawal application is withdrawn, then applicant is, is responsible for making the payment of the resolution process. And if we see, nothing explicit in regulation, but if we look at the tradition and the judicial orders, the RFP would be borne by the creditor, as the same cannot be responsibility of the applicant once submitted. And the logic being here that the applicant is a guarantor who's declaring himself insolvent. Therefore, it cannot be assumed that the cost would be borne by the applicant. It is the creditors who has to bear the cost. Also, one key thing is once a claim is filed, I could not see any provision for withdrawal of claims. So there is nothing, it can be revised, but withdrawal is not. Total period of appointment can be for 8 months from the date of appointment of RP, as 180 days start from admittance of the case after the report of RP. But from the application date also it can start, and if you add the timeline, it works out to be roughly around 8 months or so, in my analogy. Now, coming to section 100, admission or rejection of applications quickly. It says 14 days, but it will take whatever time the judiciary finds it necessary to admit of this thing. What it says is that I've already mentioned that RP can request the adjudicating authority for negotiation instructions for negotiation between debtor and creditor. And it may admit an application along with such instructions to banks or lenders. Then adjudicating authority shall provide a copy of following document to the creditors within 7 days from acceptance or rejection of the order. Order passed, report of RP, copy of application under 94 or 95. In case if the adjudicating authority is rejecting an application for whatever reason, then the application and the would be for whatever reason the rejection is happening, then the entitlement of the creditors is invoked to file for bankruptcy directly and not go through the whole process of first completing the insolvency resolution process of the guarantor, and then on failure of which to go into bankruptcy. Under section 100 subsection 4, it can directly, the creditor is entitled to file for bankruptcy. Now this is the moratorium similar to 14, section 14(1) of CRP proceedings. Moratorium starts on admittance of application number 100. It will cease on the date 180th day of AA passing or repayment, whichever is earlier, which means either on 180th day when the resolution process is supposed to end from the day of admission, or an order is passed on repayment plan by the AA, whichever is earlier. And as a consequences, any legal proceeding in respect of any debt, it stayed, excuse me. Creditors cannot initiate any legal proceeding in respect of debt, and the debtor is prohibited from transfer, alienating, impairing, or disposal of any asset or any legal right or beneficial interest.
So this alienation is not there in the earlier moratorium on the filing of application under 94 or 95.
Correct, that was not there. So till the application is admitted, it's a silent one. Yeah. Interim, moratorium, and moratorium. That's why these have been named differently. Now, let's see withdrawal of application. Rule 11, what does it say? Application can be withdrawn by applicant, maybe debtor, before admission on the request of the applicant. But once it is admitted, request of applicant can be there. However, it has to be backed up by 90% of the creditors' agreement for such withdrawal. As I shared earlier, there is no concept of constitution of committee of creditor. There is no option to withdraw after admission without 90% agreement. And of course, it has to be made in Form D of the rule. And fee and expenses incurred by RP shall be paid, or RF resolution process costs will have to be paid by the applicant. Now, section 98, when we are dealing with the resolution professional, also gives a leeway for replacement of resolution professional. However, there is a small catch that I've understood. I haven't come across in my own experience a case where we have seen the replacement, but what I understand from the regulation and the law is the replacement of resolution professional as provided can happen. However, there is no recommendation provision. So as creditors, if we want to replace the resolution professional, we can make an application to the adjudicating authority for replacement of RP. However, there is no recommendation that you can make. The adjudicating authority on its own from the empaneled list will replace the current RP with a new RP against whom there is no proceeding pending, or any kind of action by board or IPA is not pending. So quickly run through, the debtor can also replace the RP by making an application, unlike CRP where the CD is not having. So here, since the application is made by the key changes, the debtor can make an application, the creditor can make an application. Unlike CRP, here the debtor can also make an application to the A for change, but the debtor will have no choice of RP. It is decided by the adjudicating authority. The creditors can also replace by making application, and creditor alone also would not have any choice of RP. A would replace the RP and appoint from the panel of RP provided by IBBI duly verified disciplinary proceeding. There is one more requirement, that the creditors may replace the RP and appoint a new RP in a meeting of creditors. However, 75%, more than 75% voting has to be in favor of replacement. Then only, unlike 66 in CRP, it has to be more than 75, then only the replacement is possible. Only once a voting of more than 75% takes place, then the application can be filed for replacement of RP. Of course, the law directs the earlier RP to cooperate with the new RP, hand over all that. Now, public notice, once a case is admitted, a public notice has to be issued under 105. Under the law, that responsibility of giving the public notice is primarily with the adjudicating authority. However, in practice, the benches are directing RP to give public notice in the appointment orders itself. So, of course, the notice should provide information, detail of order admitting, particulars of RP, last date of submission of claim. The There is no specific form that has been prescribed. And there is a 21-day period for the creditor to file their claims. Similarly, in the bankruptcy proceeding also provides that AA may direct the bankruptcy trustee to issue the public notice instead of doing itself. However, this has not been specified very clearly in the case of insolvency. The bankruptcy proceeding, yes, it specifies the AA can direct, but in insolvency proceeding, it is not. Okay. And the standard terms of public notice to be issued in a leading newspaper, one in English, one in vernacular language, where the debtor resides, etc., is there. Public notice to be displayed on premises of AA to be done by the registry, and the website of AA to be done by the registry. So a copy of the notice has to be submitted to the registry for it to display on the website of adjudicating authority by the registrar. The creditors shall register claim in Form B with RP through either email, speed post, registered letter, etc., within the or before the last date of submission as per the public notice is 21 days. And in addition to the claims, whatever information, usually the personal identification or the creditor's identification information, etc., is asked in the form that needs to be submitted. Whatever is the cost for submitting that claim has to be borne by the creditor. If there is a cost for proving that claim, either as per the information utility records or other evidences, that is to be borne by the creditor. RP is entitled to call for more information and evidences for making or verifying the claims before collation. If information is not adequate, he can make best estimate. RP can modify the claims, or which means the creditors can revise the claim till repayment plan is approved based on additional information, additional evidence given by the creditors. All claims, RP to verify all claims as soon as it is received, depends on what kind of business the personal guarantor had. Most of the time it's possible to do it within a limited days, but if the number is large, then it becomes difficult. And like CRP, creditors can assign or transfer their debt to any person, any other person. Of course, both the parties will have to inform the RP, otherwise the transfer would not happen because of the assignment. List of creditors. RP is supposed to prepare a list of creditors based on the information and application, claims filed, and within 30 days of public notice, which is 21 days is the time given for the creditors to submit, and RP is supposed to verify all the claims in 90 days. And list of creditors is to be prepared within 30 days of the public notice. And what all things that should include? Familiar, looks very familiar, because the names of the creditors, amount claim, amount admitted, and the security interest, like any other claim verification or list of creditor that we've seen so far. Now, the list of creditor that is prepared, just like CRP, it has to be made available for inspection by the person who submitted the claims, which means the claimants can come and inspect. A copy of that list of creditor has to be given to the guarantor. If there is any website of the guarantor, place that list on the website. Small change, present the list of creditor at the meeting of the creditors. And of course, the concept of constitution of committee is not there, but the list has to be filed with the adjudicating authority along with the repayment plan. RP can make any modification in list of creditor on any assignment or transfer of debt that we saw in the last slide, and then notify each creditor and the adjudicating authorities within 2 days. It is only applicable for assignment or transfer of debt. So if any transfer or assignment of debt is found to be valid and admitted, then it has to notify formally the transferor and transferee as well as the adjudicating authority. And these are all dealt with section 104 and regulation 7, subregulation 5 and 9. The resolution professional shall prepare a statement of affair of the guarantor. It's like putting up the financial position under section 107. And the statement of affairs shall include the following information of the guarantor: assets and liability for the preceding 3 financial years and the current financial years, details of excluded asset and excluded debt, income statement for preceding 3 financial years and the current financial years, income tax returns, again for 3 financial years, creditor-wise amount due broken up into secured and unsecured debt of the 3 preceding years, details of debt owned by guarantor to his associate, which means clearly bifurcating the related party or associated debt, associate's debt. In case any guarantee has been given in relation to the guarantor's debt, and whether the guarantor is an associate of the guarantors, that has to be elaborated in the statement of affair, and detail of financial statement for the business owned by the guarantor or of the firm in which he is a partner, as the case may be, for 3 financial years, to preceding 3 financial years. Now, how is it used? The statement of affair is to be submitted to the adjudicating authority along with the repayment plan. And in case, if it is going straight away, an application for bankruptcy is to be filed, then also the statement of affair is needed. Adjudicating authority will send notice to creditor for submission of claim based on statement of affairs submitted, which is in case of the bankruptcy proceeding. And list of creditors during bankruptcy trustee process would be made based on the statement of affair and the claim submitted. So that's how important the statement of affair becomes. Now let's look at a repayment plan. Like in CRP, we have a resolution plan. Sorry. The repayment plan has to be made by the guarantor or the debtor in consultation with resolution professional. And a repayment plan should contain a proposal to the creditor for restructuring of his debt or affair. The repayment plan may authorize or require the resolution professional to carry on the debtor's business or trade on his behalf or under his or her name, or realize the assets of the debtors, or administer or dispose any funds of the debtor. Now, what does the repayment plan include? Justification for preparation of such repayment plan and the reasons on the basis of which the creditors may agree upon the plan. So kind of justifying whatever plan, the assumptions made, reasons for making that plan, what kind of a distribution it is proposing, and why should creditors agree to it. It should clearly provide for any payment or fee of the resolution professional, including what is part of resolution process cost and any other matter which is specified as per law. Now, let's go some other things that needs to be there in the repayment plan. What we have seen the previous slide is the crux. The term of the repayment plan and the implementation schedule, including the amounts to be repaid and dates of repayment. So this is important. Plan period, implementation schedule, what amounts to be repaid and when it is to be repaid to creditors. That also has to be, when you drop the financial, you also look at your cash flows and kind of, enlist based on the asset liability matching and then the cash flows allowing you. So the timing of the repayment also needs to be specified. The period of repayment plan will start from order of adjudicating authority approving the repayment plan under 114 and ends on either notice of RP under 117 or report of RP under 118 as the case may be. And we will see what it is as we go. The sources of fund that will be used needs to be specified to pay resolution process costs, and that such payment shall be made in priority over any other creditor, like saying CRP costs will be paid in priority of any other debt. A minimum budget for the duration of to cover the reasonable expenses of guarantors and members of his immediate family to the extent they're dependent on him, provided at least 10% of the realizable income of the guarantor shall be utilized for repayment of debt. That's a catch here, which has to be complied with. A minimum budget has to be done, which is to cover the immediate reasonable expenses of the guarantor and his immediate family to the extent they are dependent, provided at least 10% of his realizable income is utilized towards repayment of debt. Financing required for implementation of the resolution repayment plan. And if the guarantor has any business, the manner in which it is proposed to be conducted during the course of repayment plan and the role of the resolution professional in it. If there are funds, the manner in which it is to be held for the purposes invested or otherwise dealt with, pending repayment. So if there are funds available today and the repayment has to be made 2 months later, what is to be done with the funds there? To be kept in the current account or to be invested in FD, or what is to be done, the manner it has to be shown. Also, the functions that are to be taken by the resolution professional, including supervision and implementation of the repayment plan. It should also state if there are variation to be done of onerous terms of a contract or transaction involving the guarantor. Details of excluded asset and excluded debts, and terms and conditions for the discharge of guarantor. So this is what the repayment plan prepared by the guarantor or the debtor has to show. Now, just like regulation 37 in your CRP, what all things the repayment plan may provide for transfer or sale of all or part of the assets of the guarantor, along with the mode and manner of such transfer, administrate or disposal of any funds of the guarantor, satisfaction, modification of any security interest, reduction in the amount payable to creditor, curing or waiving of any breach of debt due from the guarantor, modification in terms of repayment of any debt due from guarantor, manner in which funds held for the purpose of repayment to creditors and not so repaid at the end of repayment are to be dealt with, and such other matters as may be required by the creditors. Now, under section 106, a resolution professional has to do a report on this. Then RP is required to submit the repayment plan along with the report on such plan to the adjudicating authority. So, and this has to be done within a period of 21 days from the last date of submission of claims under section 102. The adjudicating authority has the power to approve or reject the repayment plan based on the report of RP under section 106. What does the RP has to say in the report is that the repayment plan which has been done is in compliance with the provision of laws for the time being in force. Repayment plan has a reasonable prospect of being approved and implemented, and it should also recommend if there is a necessity of summoning a meeting of creditor to consider the repayment plan. Provided where the resolution professional recommends that a meeting of the creditor is not required, you must provide reasons for the same. And the report referred in the earlier slide shall specify the date on which and the time and place at which the meeting should be held if it's of the opinion that a meeting of creditors should be summoned. The date on which the meeting is to be held shall not be less than 14 days and not more than 28 days from the date of submission of report with the adjudicating authority by the resolution professional. And the law says that resolution professionals shall consider the convenience of creditor in fixing the date and venue of the meeting. Let's look at the meeting of creditors as a consequence of section 106. Section 107 provides for it. The RP can convene any number of meetings. Minimum notice is 48 hours or as decided by creditors in the meeting. 33% or more of voting share can also ask, creditors having 33% or more can ask the RP to convene a meeting of creditors. Of course, the creditor can appoint an individual as a proxy in their place to attend and vote such meeting. RP has to adjourn the meeting for sufficient reason, but not more than 7 days at a time. Who can attend a creditor's meeting? A creditor who's included in the list of creditor, of course, the debtor, the resolution professional, and any person assisting RP or his members of his RP's team, any participant as would authorized by the creditor through a resolution to attend the meeting. Quorum of the meeting should be at least 33%. The creditors can decide the threshold level of a quorum to be higher than 33% for any future meeting, but this decision has to be done in a meeting of creditors. Unlike CRP, if the quorum is not present, that the meeting would be adjourned to next day, same time, same place. And with the people present, the meeting will be conducted. There is no quorum would be required for the adjourned meeting. RP will provide for all meeting of the creditors. I'm not reading out the remaining formalities of the meeting, like calling the roll call, getting a attendance sheet signed, capacity, confirming that they have received agenda documents, RP2 announcements, etc. That is the regular meeting that we do. All that is provided here for him to continue till the end of. Now, summoning the meeting of creditors to consider repayment plan. While the notice of the meeting is there, if in the sorry, RP has to mention, as we've seen under 106 in his repayment plan, if there is a necessity to summon for, if there is a necessity to summon the creditors for a meeting or not. And if there is no meeting requirement, reason has to be recorded. But if recommendation of a meeting is made, then the RP has to mention date, time, and place of the meeting. As I've earlier said, the date cannot be less than 14 days and not more than 25 days from the date of submission of RP's report under 106. And it has to be a notice calling meeting of creditor has to be given before the date fixed for such meeting. Notice to participant to whomever the creditors have agreed. Minimum 48 hours it has to be given. And if it is decided in a subsequent meeting that subsequent meetings beyond the meeting in which the decision is made can be done at a shorter notice, then a shorter notice rule can apply. However, that shorter notice cannot be less than 48 hours. Now, what are the contents of the notice calling the meeting of creditors for considering repayment plan? Address of the adjudicating authority to which the repayment plan and RP report has been submitted. Date, time, and venue of the meeting. Options available for attending in person through video conference or through a proxy. Agenda of the meeting, which is standard list of matter to be discussed, list of issues to be voted upon, relevant document for both the list of matters to be discussed and list of issue to be voted on. A copy of the repayment plan, a copy of statement of affairs, as we have seen, to be prepared, a copy of the report that has been submitted with the adjudicating authority, and proxy forms, etc., for any proxy voting that has been allowed. The options have been given. Now, the voting share of each creditor shall be in proportion to the vote, in proportion to the debt owed to such creditor as admitted by RP, which means the total value of debt that is arrived. How does the individual creditor's debt, or what proportion the individual debt has to the total debt, is the voting share of that particular creditor. The approval of repayment plan has to be with a positive vote of 75% or more. Voting share and value of debt who are present and voting either in person or e-voting. It does not say of the total voting share. What it says is with a positive vote of 75% voting share in value of debt who are present and voting. Barring this, any other decision of the creditor shall require approval of 50% of voting share of the creditors who voted. There is no condition for present in meeting. So in that case, the people who are not present in the meeting, maybe a e-voting has to be conducted, and then 50% of the voting share has to be taken. And RP is tasked to take a vote on the of the creditors present in the meeting on any item that is listed for voting after discussion on the same. RP is required to circulate the voting result after the meeting along with the minutes or later if the voting is being done electronically within 24 hours of conclusion of e-voting. However, the minutes of the meeting has to be circulated within 48 hours. So either if the physical voting is done in the minutes in the meeting, then along with the minutes, the voting results be circulated. If an e-voting is getting done or subsequent to meeting, a voting is being done electronically, then it can go after the minutes have been sent, but within 24 hours of conclusion of the e-voting. And the e-voting has to be open for 24 hours after circulation of the minutes for those who did not vote at the meeting. There's one clear-cut demarcation that has been made. A creditor shall not be entitled to vote in respect of a debt for an unliquidated amount, which means where exact amount of debt is yet to be determined. So if there is a debt which has been provisionally admitted, but we don't know the exact amount, there's no voting entitlement. And in any of the meeting, as we have seen earlier, repayment plan voting associates debtor is not entitled to vote. Now, what happens to the secured creditor in case of a repayment plan? There are two options. Secured creditor forfeits its right to enforce security interest during the period of repayment plan, participate in the meeting and vote as per full admitted debt for approval of repayment plan. Which means, like CRP, his rights to enforce security is forfeited or it's not there, and participates in meeting and votes on the full count of his claim admitted. Option 2, secured creditor submits an affidavit to RP at the meeting saying that he will participate or she will participate and vote in the meeting only for the unsecured part of its debt. Then the secured creditor not only files an affidavit, which means it intends to realize its own security. So the basis and calculation for the unsecured portion also has to be submitted to the RP. Then in the repayment plan, based on the affidavit given by the secured creditor, the secured and unsecured part of the debt of this creditor has to be considered separately. Now, repayment plan, if it contains any provision which affects the right of the secured creditor in enforcing its security, then the concurrence of the secured creditor is required for approval of repayment plan. Because we have seen the very first point, it submits an affidavit saying that it will participate and vote only for its unsecured part. However, if the repayment plan contains any provision which affects the realization or the right of the secured creditor in enforcing its security, then before the repayment plan is put to vote or it is approved, the secured creditor's concurrence for that provision of the repayment plan which affects its right for enforcing the security is given by the secured creditor. Then only the voting on the approval of repayment plan should happen. RP has to prepare a report of the meeting of creditors on repayment plan. And what are the contents? Whether the repayment plan was approved or rejected. If approved, if any modification made to it before approval, what are the resolution proposed, passed or rejected in the meeting, a list of creditors present at the meeting, voting record of each creditor for all meeting of creditors, and any other information that RP thinks appropriate for AA, and this report has to be paid and submitted under section 112. Approval of repayment plan by creditors under section 111. The repayment plan or any modification shall be approved by a majority of 75% of the voting share. You've seen that. Now, approval of repayment plan by, once the meeting has happened, the creditors have approved, what happens? The adjudicating authority, once it gets a report, adjudicating authority gets a report of the RP, may approve or reject the repayment plan based on the report of creditors as submitted by RP. In case of meeting of creditors is not summoned as recommended by RP with the reasons given, the adjudicating authorities still have the power to pass an order for approval or rejection based on the report of RP under 106 on repayment plan. It can give directions for implementation of repayment plan, where adjudicating authorities of the opinion that repayment plan needs modification, then it can direct the RP to convene a meeting of creditors for reconsidering the plan. Once a repayment plan is approved, it is binding on debtors and all creditors mentioned in the plan. And where a repayment plan is rejected by adjudicating authority under section 114, then the debtors and creditors shall be entitled to file bankruptcy application. Of course, copy of the order of the adjudicating authority shall be provided to IBBI for entry in register. Implementation and supervision of repayment plan, section 116. It is duties cast on RP to supervise, and RP may file an application to adjudicating authority for direction for any matter arising out of implementation repayment plan that the RP deems necessary to seek any direction. It may go to the A, and A may give such directions. Then the RP, within 15 days of completion of repayment plan, has to forward two persons bound by repayment plan and A the following documents. One, the notice that repayment plan has been implemented fully. Report of RP showing all receipts and payments made as per plan and extent of implementation, and comparison of implementation with the repayment plan. So X was supposed to be paid by this date. What is the implementation? X has been paid as X, plus or minus, or the date, which was Y, it is plus or minus. So comparison of this time of 15 days as given in section 117 can be extended by 7 days by the adjudicating authority on an application of the RP. In case if the repayment plan comes to end prematurely, what happens? It's dealt with section 118. Repayment plan is not fully implemented within time as per repayment plan. Then RP is cast upon a duty to prepare a report and shall submit and RP shall submit to adjudicating authority receipts and payments made as per the plan, reasons for premature end, and details of creditors whose claims are not paid as per plan. So this report, where repayment plan is coming to end prematurely, has to show three parts. One is the creditors whose payment has been made, including the sources from the receipts have been made either on sale of asset or realization of debtors, etc., etc. Why the repayment plan is coming to an end prematurely? Maybe one of them could be the realizations anticipated in the repayment plan. 20% of them did not fructify within the repayment plan period, or they are not coming, or they have become bad, or whatever reason, or any other reason, as the context and the facts of that case would be reasons for premature end. And obviously, repayment plan is ending prematurely, or it's not being completed, which means there are certain set of creditors whose claims are not fully paid or not satisfied. Who are these and what are the amounts due to them? The adjudicating authority shall pass the order of repayment plan has not been fully implemented, and the debtors and creditors whose claims are not fully paid can make an application for bankruptcy of the. Of course, the adjudicating authority shall forward the report, RP's report, and its order to all persons bound by the repayment plan, including debtors and creditors. And a copy of that has to be forwarded to IBBI. Now,
So we can take the 10 minutes break. You have been continuously speaking from past 2 hours.
no, let's continue for some more time,
All
maybe
right.
another 20 minutes or so, and then we can take a small break.
Sure, sir. Sure.
Let's straight away go to section 138. And I will sum it up later how a discharge is a good thing for a guarantor. But let's look section 138. What does it say? And this is we move to bankruptcy proceedings. So BT is the bankruptcy trustee. It has to apply to the adjudicating authority for a discharge order. And this discharge order has to be on expiry of 1 year from the bankruptcy proceeding commencement date, or within 7 days of the approval of creditors of completion of administration of the state, if obtained prior to 1 year. Adjudicating authority shall pass a discharge order if satisfied. Let's look at it. What happens once a discharge order is passed under section 138? It shall release the bankrupt from all bankruptcy debts, which means it's a fresh lease of life. We can go around, borrow, start a new life, start new businesses, again, start giving personal guarantees if it deems necessary, except from any debt incurred by means of fraud or breach of trust to which he was party. Which means any debt incurred which arose because of fraud or breach of trust to which he was a party will not be, which means fraud and breach of trust, there is a ruling against him or the PG, which he'll not be discharged from. Normal commercial debt, he'll be discharged, everything. And the debts which was excluded under Section 79, he is not discharged from that because that's excluded from the proceeding. A discharge of the guarantor or the debtor will not affect functioning of the bankruptcy trustee or operations of the bankruptcy process and administration and distribution under the bankruptcy process. So please understand, within 1 year of commencement of bankruptcy proceeding, discharge is given to the debtor. But the liquidation of the bankruptcy estate may not have fully happened. All the debts were not satisfied, then administration and distribution can continue. And the functioning of bankruptcy trustee also would continue because the bankruptcy trust is vested with the bankruptcy trustee. It does not remain with the debtor. I've already mentioned this. So here you may be wondering the detail of bankruptcy proceeding. I think they're very similar to the action to be taken like CRP, because once an acceptance of bankruptcy, and I haven't seen any case which is to bankruptcy as of now. Most of the cases are pending at the stage of insolvency proceeding. The bankruptcy trustee is appointed and he takes charge of the bankruptcy state of the debtor. And then, as per law, he is supposed to, just like a liquidation process, he's supposed to go about liquidation of the asset and distribution of that asset to the claimant or the claims holder, stakeholder here, in line with the repayment plan post or in line with the values that can be given. I have not taken that in detail for the simple reason that we don't have too many cases at this point of time, or to my knowledge, none I've seen which has moved to bankruptcy. So I just didn't want to simply, read the regulation there. However, I've taken the discharge part because that's very important from a perspective of making anybody to whom you advise or any case that you are handling, that a personal guarantor, if he undergoes the process, he or she will be able to get a discharge beyond a certain time. We have to just add the timelines, 180 days plus time for probation, and 1 year from then, once the bankruptcy is admitted, 1 year from that, he gets a discharge, and then he can start a fresh life, start new businesses, can start borrowing, etc., etc. And that would be maybe consider that as a boon to a personal guarantor having landed into a precarious situation. Quickly, let's look at some avoidable transaction that can happen. So I'm including this part because the law talks about these transactions, but you must understand only the bankruptcy trustee can apply and not the RP for any transaction between the bankrupt or the debtor earlier or any other person. So for filing an application for undervalued transaction under section 64, only the bankruptcy trustee can do it. The look back period is 2 years ending on the date of filing of bankruptcy, which means 2 years prior to that. The transaction should have caused the process to be triggered. And the transaction between the bankrupt and his associate will be deemed as undervalued transaction, and provision of this section will apply. Transaction in ordinary course of business is exempt, but not applicable to transaction with associates. So any undervalued transaction done with associate, look back period of 2 years, can be made part of this application. Transaction in ordinary course of business is exempt. What is the nature of undervalued transaction? Making a gift to a person, no consideration is received from that person by the bankrupt, or it's in consideration of marriage, consideration is less than market value. These could be some of the nature of undervalued transaction. And adjudicating authority can pass an order making this transfer void and vest it back with BT, restoring the earlier status. Similarly, preferential transaction, which is covered by section 165, here again, only the BT can apply, not the RP. Look back period here is again 2 years, but here, if it is done with associates, and for any other transaction falling under the ambit of preference transaction, 6 months is the look back period, other than if it's done with other than people other than associate. The process remains same. And the AA can pass order declaring transaction void, property transferred to vest back with the bankruptcy trustee and form part of bankruptcy estate, or restore its original position. Similarly, for extortionate credit transaction, look back period is 2 years. And the terms of transaction providing credit should be exorbitant and unconscionable under the principles of law. I think section 50 also provides a similar ground. So one can, draw certain parallels, because many applications under 43, 45, 50, 66 have been filed. Certain parallel from that practice, to the extent it's applicable here, contextually can be done, and then see what these sections specifically say, and then the application can be filed. And this, as there, it's not applicable to regulated financial service providers. Now, quickly, to moving towards more or less summation and looking at the disadvantages that a personal guarantor or the liabilities that is causing or the penalties he has to pay. Let's look at also the scope of work that the RP has to do. A lot of responsibility, Mr. Das also spoke about it. A lot of power and responsibility has been given to the IP, who's working as a resolution professional in these circumstances. So what does the scope of work looks like? Let's run through quickly one by one. Applications to be filed by RP. That's one. Maybe. Preparation and submission of a report under section 99. Then issue a public notice, receiving claims, registering claim after verification, preparation list of creditors under 104, preparation statement of affair, preparation of repayment plan with, not consultation, with advising the debtor to prepare, preparation and submission of report of meeting of creditors on approval of repayment plan, preparation and submission of report of RP on repayment plan, submission of meeting, then supervising implementation of repayment plan and making an application for any direction, report on the full implementation of plan or part implementation of failure of repayment plan. Also for a discharge order for debtor under section 119. So there is a lot of reporting directly. Here, the reporting is not to the committee, only sharing, but reporting directly and submitting the report to the adjudicating authority. So there is a lot of work in terms of, submission to the adjudicating authority is to be done by the resolution professional here. Now, what is the moratorium when it happens in the bankruptcy proceeding? Unlike insolvency proceeding of the personal guarantors, the estate of the bankrupt will vest with the bankruptcy trustee. And it is to be divided, estate of it will be divided amongst his creditors. Of course, there is an embargo on creditors to take any action. One key thing is the moratorium will not affect the rights of the secured creditors until unless they decide to relinquish it. And no interest is payable to any secured creditor during this period. This is one of the key things which happens for the bankrupt or the personal guarantor. See, he may earn a disqualification under contract for breach of contract. There is a possible disqualification. He cannot be appointed as a trustee. He cannot hold a public office. This is some of the key drawbacks that a personal guarantor suffers when his case moves from resolution to bankruptcy. Cannot hold a public office for which the appointment is done by election, cannot be appointed as a public servant, cannot be elected, sitting or nominated as a member of any local authority. Of course, this will apply only till the discharge order is given or modified. He cannot be, restrictions are there, he cannot act as a director or take part in promotion or management of a company, cannot create charge on estate, take further debt. He cannot enter into any transaction of 1 lakh rupee or more without informing all the party that is undergoing bankruptcy for. Cannot maintain any legal action or proceeding without specific approval of adjudicating authority. Cannot travel overseas without specific approval of adjudicating authority. All these restrictions will apply till his discharge. Now, what are the priorities like 53? The priorities are defined for payment under bankruptcy. Similar waterfall mechanism, cost of bankruptcy process, tops the chart, workman dues for 24 months, secured creditor rank pari passu, thereafter employees 12 months, government dues, and all other dues. A small change. The government dues come before the unsecured financial creditors. Like unsecured financial creditors would come here as unsecured debts. Now let's quickly look at the timelines. I will not invest much time on this. Quickly look at the timelines, what the law says, and how 180 days is described. Service of notice is 14 days. Filing of application, it takes another maybe 10 days or 15 days. And once till the date of the interim moratorium continues. Then after that, the appointment of RP by A and admission happens. Within 10 days of that, he has to submit a report. Then that application within 10 days of his, or this thing under 99, he has to file. And based on his report, the admission or rejection happens. The period of 180 days starts from here. So if you recall, I said the RP works for 8 months. The calculation is here till that almost 60 days goes past till the time the admission for resolution proceeding of a personal guarantor happens by the adjudicating authority. And then from here, the 180 days period starts. Can you see this? This is once the RP submits his report or her report under section 99, then the admission of application is decided by the A, and the 180 days starts from the time A order comes for admission. Then these timelines are another 7 days. Receiving of claim 8 to 21 days, because 7 days he has to public notice. 21 days for the claims. Verification of claim, 9 days is allowed or something like that. Preparation of list has to happen within 30 days. So verification and listing of creditor happens after the notice, 30 days from the notice. Another 21 days for submission of RP's report under 106. That takes it to 49 days, then submission of meeting of creditors considering plan within 28 days. That takes it to 77 days. Subsequent meeting for approval of repayment of plan or modification. It may be anywhere between 78 to 120 days. Filing of repayment after approval of creditors with a report of RP on 120th day, providing copies in the next 3 days, 123 days. A may ask RP to modify repayment plan or convene another meeting. It could happen anything from the 123rd day to 128th day. And approval of repayment plan also. It's assumed. So 180 days is the initial. And like liquidation, bankruptcy proceeding could continue for a year, and then with the approval of the authority, it could go on further. So I have not listed that time chart because that's not necessary. Here the timelines are necessary. Now let's also look at What are the offense and penalties? I've listed for both as given in the sections. The liability of the guarantor, being the debtor, of course, is listed here, and the creditor also, as well as the RP. So punishment for false information by a creditor. Debtor or creditor provide false information to RP. Material particulars. Punishment to debtor or creditor up to 1 year. This section 184. Or fine up to 5 lakhs or both. Creditor promises to vote in favor of repayment plan dishonestly by accepting any money or property from debtor. Punishment to creditor up to 2 years. Fine up to 3 times of the property accepted by creditors of 5 lakhs, if not quantified, or both. For contravention of section 185, if IP, which is the RP here, if they contravene any provision, the punishment of RP up to 6 months and fine up to 1 to 5 lakhs or both. Punishment to bankrupt for false information, concealment, etc. by bankrupt in 186, where he is knowingly making a false representation, willfully omits or conceals any material information, non-disclosure of details of disposal of any property which would have been part of the estate while making an application under 122, or while providing any information during the proceedings. The punishment to bankrupt up to 6 months or fine up to 5 lakhs or both. Where he withholds information, destroy, falsifies, alters his books of account, financial information, other record. Here also punishment to the bankrupt can go up to 1 year and fine up to 5 lakhs or both. It could be a mixture of both. And in case the disqualification that is earned by a bankrupt, if it is contravened during the period, disqualification or restrictions are there too. Again, the punishment can go up to 6 months or fine up to 5 lakhs or both. Now, where it has failed to deliver the possession of any property which is part of the estate of bankrupt, which was under a possession of control, then again the punishment to the bankrupt could be up to 6 months, fine up to 5 lakhs or both, or he has failed to account for any loss incurred for any substantial part of his property, which is part of the estate or which would have been the part of the estate, without any reasonable cause or satisfactory explanation. From the date which is 12 months before filing of the application, if it's caused anything like that, then the punishment to bankrupt is up to 2 years, fine up to 3 times of the value of loss of 5 lakhs, if the loss is not quantified. If the loss is quantified, then fine can be up to 3 times the value of loss or both. Or he is absconded or attempted to abscond after the bankruptcy commencement date. The bankrupt shall be deemed to have absconded if he leaves or attempts to leave the country without delivering possession of any property which is required to deliver to the bankruptcy trustee. In that case, all the punishment would be up to 1 year and fine up to 5 lakhs or both. Under 187, where the bankrupt or the personal guarantor has fraudulently misapplied, retained, or accounted for any money or property which would have been part of the estate or which is part of the state, or has willfully acted in a manner that the estate of the bankrupt has suffered any loss in consequence of a breach of any duty of the bankrupt, or carrying out his function under 49. Punishment to the bankruptcy trustee. This is not for the bankrupt. This is for the trustee or the RP, which will become the bankruptcy trustee. The punishment can go up to 3 years and fine up to 3 times of the loss caused or likely to have been caused, or 5 lakh if the amount of loss is not quantifiable or identified, or both. BT shall not be liable under this section if he seizes or disposes of any property which is not comprised in the state of bankrupt and at that time has reasonable grounds to believe that he is entitled to seize and dispose of that property. So action taken in good faith, he'll not be accountable or he will not be punished. I think let's take a break now and then we will come back. Is that okay?
Sure, sir. Sure, sir.
Can we begin?
Sure, sir.
Rashla?
Yes, sir. Yes, sir. Am I audible, sir? Am I audible? Sir, you can begin with the session.
Welcome back, dear participants. Am I audible now?
Yes, sir. Yes, sir. You're audible.
Yes, sir, you are audible.
Thank you. Sorry, I took a little more than 10 minutes. Thanks for waiting. The next part that I want to take you through is the series of case laws where the judgments have come in primarily in 2022 that I've listed down. I'll discuss certain facts, observation, and the directions given by honorable courts, tribunals, honorable courts, and see this what has been directions or what part of the law appears to be settled, or certain issues, a certain part of this insolvency proceeding of personal guarantors settled by these judgments. So let's look at the very beginning. I have the case which is the key reason I this is the insolvency proceeding of personal guarantors are stuck or kind of standstill has happened. So this is just a moment. Sodi versus Union of India and others, Honorable Supreme Court, and this is against writ petition number 307 of 2020, where SPL had filed an application under 95 of the code, seeking initiation of CRP against personal guarantor Mr. Gurmeet Singh in NCLT Chandigarh. The matter was admitted and Mr. Anup Sood was appointed as RP. Honorable NCLT directed the RP to comply the provision of section 99 of the code and submit his report before the next year, 26/5. Meanwhile, Mr. Suri, the personal guarantor, approached Supreme Court in a writ petition under Article 32, raising constitutionality of section 95 of the code, which was not covered because a lot has been covered in Lalit Kumar Jain case, which we will briefly discuss here, which was brought up here. So, what is bench did after the arguments that RP shall not proceed with the filing. At the same time, ask the petitioner not to transfer, alienate, encumber, or dispose of any of his asset or his legal right and benefit therein. The case has been on stay, and this has been tagged with a matter titled Surendra B. Rajka versus Omkara Asset Reconstruction, Civil Appeal 16464 of 221. And across the country, our own experience, as well as what we have heard from IPs and in different forums, discussions and sharing of information that has happened. In this case, may I request, dear participants, please put your on mute. Disturbance.
हेलो आजा नीचे नीचे आ
Ji, please, mic, sir. Because of the stay granted in with Sodi case, most of the cases relating to your personal guarantors, best of my knowledge, today are getting adjourned, and NCLT, or if there are something which has gone to NCLAT, cases are adjourned and possibly the tribunal is waiting for Supreme Court's decision and maybe Jivarjaka in this particular case where it has been tagged. So this case also been tagged. So having seen this, let's move to another one where case Shah versus Union of India were filed after Gurmeet Sodhi, in view of Gurmeet Sodhi. That the issue involved in these petitions are similar or akin to that was in the pending. The validity of section 95, 196, 197, 599, and 100 of insolvency notices have been issued with orders. Only interim, what you call, along with the stay, directions have been given petitioner not to transfer their, alienate their right, etc. And a clear stay specific case by either clubbed together or wherever the petition have been independently filed, direction given RPs not to see the filing of the report. And if that been still the same shall not be acted upon. So there are many cases. Good friends, 17, there the mentioning was something else. So we feel that anyone can file a petition and get this order now. Before. Let's see the case. Mahendra Kumar, State Bank of India. State Bank of India filed an application under Section 95 of the Code seeking initiation of CRP against the guarantor. Sorry, that's my side. It can't be CRP against guarantor. The application was dismissed as premature and observed that no CRP or liquidation proceeding is pending against the corporate debtor because of the approval of the resolution plan as on date. Section 60, subsection 2 of the code requires that for a CRP to be initiated against the guarantor, must be CRP or liquidation process is pending against the corporate debtor. NCLT's observation was challenged. So the appellant's argument was Honorable NCLT, while interpreting Section 62 of the Code, the application was fully maintainable, despite there being no pendency of any CLP in NCLT. Respondent's argument, respondent being the guarantor here, Section 60, subsection 2, an application of CRP of the corporate guarantor, personal guarantor can be filed even if CRP and liquidation process are pending. And they're saying NCLT rightly rejected the application as premature. And its observation was Section 60, subsection the code does not in any way prohibit filing of proceeding under Section 95 of the code, even if no proceeding are pending with NCLT. And provision of section subsection 2 are without prejudice. Sections 60 subsection 1 are supplemental to section 60 and subsection 1 of the code. Application filed by the appellant was fully maintainable. And Honorable Supreme Court made observations of the Honorable Supreme Court was it upheld the NCLAT decision, which means Section 60 subsection 2 of the code does not prohibit filing of proceeding under Section 95 of the code, even if no proceeding are jurisdiction will be A may be different. If there is no proceeding pending, an individual's case, it may go to DRT. There is no restriction. An application under 95 of the code can be filed against personal guarantor of corporate debtor before NCLT, absence of any pending CRP or liquidation proceeding against corporate debtor before such NCLT. This is very clarificatory one. If you've noticed, it also clearly says go before NCLT. Now we have been saying there is no proceeding, nothing, go to DRT individually if it is invoked against individual only. However, observation of Honorable Court is application under 95 can be filed against the guarantor of corporate debt for NCLT, even in absence of any pending CRP liquidation proceeding against a corporate debtor before case in terms of understanding filing of application under application 60, under application and under sections 95 not contravene 60 subsection 2 where there is no prohibition. Let's move to first outed judgment of 21st May 21. This is the only case that in 21 is a very important judgment, and I've tried to in 3 bullet points here. Honorable Supreme Court in the matter of Lalit Kumar Jain versus Union of India and others. And the key 3 points, according to me, if any one of you have more point, then please, which is very important. And that any recourse under section 133 of the Contract Act 72 discharge the liability of the surety account of variance in terms of contract his consent. Language of one of the codes makes it clear that the approved plan is binding guarantor to avoid any attempt to escape liability under the which means the approval of plan, etc., is change or variance in the terms of act which has happened with consent guarantor. It has happened without the consent guarantor. Creation code says that section 31 of the code makes it very clear that the approved plan is binding on guarantors. Any attempt to escape liability under the provision of the Contract Act 1972, the one. So because of the resolution process, even if there is a variance in terms, guarantor is liable. She does not escape. Next point, the sanction of resolution plan, penalty to it by section 31, does not per se operate as a discharge of guarantors. Other argument here, let me read this fully. To the nature and extent of liability, much would depend on the terms of the guarantee itself. However, involuntary principal debtor leading to loss of security not absolved guarantor of its liability. Of a resolution plan 31 may satisfy a part of the debt. Then it is very much clear that lenders, the remaining part of the debt, can seek other remedies, including insolvency of the guarantors, operator, personal guarantor, to realize that they have disposed of the claim that they have. Only in case if the resolution plan satisfy 100% of the debt, since the debt gets extinguished, they don't have a recourse. Without the debts on the book and the default, recourse against anything. Or in a case where the debt is partly satisfied, the remaining part of the debt is assigned to either the resolution applicant or it is given to an associate of the resolution applicant. The right to enforce that debt passes on the assignee of that. Cannot take any action against guarantors in that case. However, if the debt is partly satisfied, the guarantor's liability is not extinguished. Continuing, approval of a resolution plan does not also factor the strategy of a CD his or her liabilities under the contract of guarantee. Release or discharge of a principal borrower, the debt by its creditor by an involuntary process, that is operation of law, to liquidation or involuntary proceeding, does not absolve the security guarantee of his or her liability which arises out of an independent. We discussed earlier clearly emphasize honorable court here in its order saying that approval of resolution plan does not absolve, and goes a step ahead is saying that the liability of the guarantor arises out of independent. And so the liability, the onuses that has been placed upon by that independent contract needs to be satisfied. It does not get the approval of the resolution. Let's move to the next case. This is Kosi versus Rati Finance. Law here, approval of a resolution in respect of one borrower can discharge a. Let's see the facts. The financial creditor disbursed a loan of 6 crores to Premier Limited under 3 separate loan pledge agreements. Loan pledge agreements stated 2 distinct transactions under one document: grant loan to Premier and creation of pledge Doshi holding of Premier. Corporate debtor failed to make payments. FC called Premier and Doshi to pay the entire outstanding, neither paid. FC filed section of a CRP default of so much. Same day, FC also filed petition against guarantors on the same loan document. The petitioner were heard together on 29th of January 21. The authority admitted the petition against Premier. On 19th February, holding, which is the same set of loans arising in the same loan document. The appellant filed an appeal in NCLAT under section 61 of IBC. Aside on 21 dismissed. The order of admission of sections of IBC. Observations. Here, she being a pledger does not disentitle it proceeding under 7 against such a co-borrower. Holding with a pledge agreement in its dual capacity, borrower and pledge of share. Pledge per se may not be a financial. However, in this case, Doshi holding was a borrower. Lalit Kumar Jain versus Union of India, the Supreme Court held that the approval of a resolution plan in relation to debtor does not discharge the debtor. On parity of reasoning, the approval of a resolution plan in respect of borrower can only discharge co-borrower. But borrowers, 2 corporate bodies fall within the ambit of corporate debtor. No reason why proceeding under IBC cannot be initiated against both the corporate debtors. Same amount cannot be realized from both the corporate debtor. If dues are realized in part from one corporate debtor, the balance may be realized from the other corporate debtor, being the co-borrower. However, once the claim of financial creditor is discharged, there can be no question of recovery of claim twice. So, the co-borrower dues are not realized becomes liable, proceedings is valid. Next, Delhi High Court one, which is Access Trustee Service versus Bridge Bhushan Singhal, 21, judgment given on but 22. Question of law before the Honorable Court, Interim moratorium under section 96 IBC in respect of co-guarantor so applied to the other co-guarantor defendant number 2 for the same debt as the liability of both the co-guarantors from the same debt. Is interim moratorium by the Honorable Court is interim moratorium in respect of one guarantor to apply against. Effect of interim moratorium is limited to the debts of a single debtor. It cannot include independent in relation to CD. Reference to debts of section 96 IBC is in respect of a particular debtor evident from 96 1B clause 2 of the IBC to the effect that the creditors of the debtor shall not initiate legal action or proceeding in respect of debt. Therefore, the effect of interim moratorium is only in respect of debts of a particular debtor. The ex-promoters are independent guarantors in respect of corporate debtor, joint and several liability. Creditors would have an independent recourse against each of the guarantors. Creditors would have an independent recourse against each of the guarantor. The inability to recover against one of the guarantors would not come in the way of making recoveries against the other. So, an interim moratorium in respect of one co-guarantor would not apply to the other co-guarantor. That's what, in short, this judgment tells us. Let's look at the next one. Kiran Kumar Moolchand Jain versus TransUnion Civil Madras High Court. Observation here again related to on reading of section 96 of IBC, it is evident the interim moratorium applies to any legal action or proceeding in respect of any debt to the initiation of any legal action or proceeding by the debtor in respect of any debt. The expression used in section 96 is in inverted comma in respect of any debt, not for recovery of a debt. So what the Honorable Court says here is the interim moratorium applies not only to proceeding for recovery of a debt, but to proceeding in which the liability of the borrowers and guarantors are determined in relation to the credit facility. It applies to debt. It applies to any debt, means all debts. So interim moratorium applies against all debts of that particular Kumar Ghai versus Prithpal Singh Babbar, High Court, Punjab and Haryana. Just to the we discussed in the previous case, interpretation of the phrases, all the debts, legal action or proceeding in respect of any debt, referred in section 96 of IBC and proceeding under section 30 of NIA. The check was issued by the personal guarantor is personal, not in any manner in discharge of any corporate debt. Consequently, even though the respondent herein may suffer longer delays due to the stay that would be deemed to be operating on the proceeding in the complaint, by virtue of the interim moratorium stated in section 90, there would seem to be no option with this court but to allow the petition set aside the judgment by the learned Angela that dated. So what it says that a check was issued, however, this check was for anything else, not for discharge of that CD trinket ratage. It says interim moratorium given to the personal guarantor is against debts, not only against satisfaction of. So here, in case of check bounce also, that proceeding also got stayed. And still a decision is taken by the adjudicating authority in terms of section A application. Proceeding before the learned trial court section would remain stayed. Adjudicating authority request to explain. Let's look at the decision taken in Amit Jain versus Siemens Financial Services Private, NCLAT, New Delhi. This is Company Appeal 292. This is a question of law that came. The benefit of Section 10A of IBC be claimed by a personal guarantor. An application under Section 95 shall be barred for a different reason or after 25th 2020, 24th March 2020. The Honorable observation. Section 95 of IBC is in part of the code, which contains insolvency resolution, bankruptcy for individual, and part 3, chapter 3 deals with insolvency resolution process. Chapter 95 is part. When section 10A was inserted in chapter 2 part 1, no corresponding amendment was made in chapter 3 of the code. Basis of statutory interpretation, provision of section A is capable of only one meaning, that suspension of initiation of CRP was only for corporate debtor. Legislature intended suspension of CRP against the personal guarantor also. Similar amendment made in chapter 3 part 3 of the code. Very clear, which means that the holiday period or the saving period that has been to.
Hello. Hello. Excuse me, sir.
Hello.
Sir, your voice is continuously breaking.
Sir, I saw your text and it is audible from our side, so I could not find any problem in the voice.
No, madam, we are not able to hear actually.
Yes, madam, we are not able to hear properly.
Yes, madam. Frequent disconnection and rejoin.
Sir, I am talking to IT team, but there is no issue from our end. So maybe we can join it again. Because sir, if
Madam, many of us
audible
are writing on the chat box. No one is responding from your side.
Yes, ma'am.
Many of us are writing.
Yes,
Sir,
kindly see a check.
Kindly see the chat box.
Sir, I
Yes,
have
ma'am,
checked the
please.
chat box. Only after that, I'm telling
So
you.
many
that
people are facing the issue.
Sir is
Just see the chat box.
See,
sir, I've
ma'am,
seen
yeah.
the chat box. I've
Sir,
seen
we
the
can,
chat box.
he can log in again, sir. I mean, it's a small issue, no problem, sir. He can log in again.
Sir, I am continuously talking to the IT team and there is no issue
Yes,
from
he
our end.
can log in again,
That's
sir.
what I'm
There is
trying to say.
no problem, ma'am. No problem. We can log in again. I mean, this is not a big issue. Please.
Thank you.
No, you want me to log in again? I have no issues.
Sir, please do that. I believe there's
Yeah.
a little bit of there's a voice distortion. That's all, sir. Please do that.
No, but technically I understand one thing. If you are able to hear me clearly,
Yeah.
then my connection is all right.
Yes, Anand sir. I
I'll
mean,
do that.
now it is good.
I'll do that.
Sir, there is no connection
We need to
issue from
resolve
our
this.
end also. I have
Yes.
seen the chat box and I was talking to the technical team and your voice is clearly audible to me. So That's what I was trying to figure out.
Madam, now you are clearly audible, but her voice is constantly breaking. That's why we were insisting again and again.
All right. Sorry for the inconvenience. You may please continue.
Am I audible now?
Yes, sir, you're audible.
Yes, better.
Okay, can we proceed?
Yes, sir. Yes.
I'll just quickly take out. So we have discussed this, that section 10A relief which was given for any kind of a default arising due to COVID period is not available to the personal guarantors whose resolution falls under chapter 3 of part 3. Let's go to the next one. It is Sudeep Bijoy Datta versus State Bank of India. And the judgment came in July 22. The question of law here is whether proceeding under 95 of ABC against a personal guarantor before NCLT, even after citizen of another country, even after getting citizenship of another country, whether it was necessary for the central government to enter into an agreement with government of Singapore as is required under section 234, 235 of the code to enable the NCLT to proceed under 95(1) of the code against appellant. Now let's look at the facts. Sudeep Datta, SD Aluminium, incidentally, this case was handled by one of my partners, the CRP of this particular and then subsequent liquidation. Sudeep Datta, director of SD Aluminium, executed deed of guarantee dated so and so in favor of SBI. Facility availed by the corporate debtor, and in 2020, Section 7 CRP admitted under Section 7 against the corporate debtor. The appellant, who was a director, acquired the citizenship of Singapore in 2018. So he gave guarantee in 15. The CRP initiation happened in February of 20. In June of 18, the director acquired citizenship of Singapore and then challenged this application filed by SBI under Section 95. Then two appeals arose against the order passed by NCLT appointing RP and directing him to recommend whether application under this thing is filed or not. So against the application filed by SBI under section 95 against the personal guarantor, the director of SD Aluminium, who had acquired citizenship of Singapore between the date of signing the guarantee deed and the date on which the CD went to CRP, and NCLT on application being filed under 95 appointed the RP and directed the RP to file an application under 95, etc. Sorry, file a report. And this was challenged by the director. So what was the challenge when it went to NCLAT? Section observations that section 60 subsection 1 provides that A, in relation to insolvency resolution for corporate person, including personal guarantor, shall be NCLT having territorial jurisdiction over the place where registered office the corporate debtor is located. So, and the jurisdiction point is very clear because the personal guarantors jurisdiction, if CRP proceedings started, and if we go by Jajodia's order by Honorable Supreme Court, it is the registered office of the CD which determines the jurisdiction under 60 subsection 1. So the observation of the NCLAT in this case was that section 60 subsection 1 provides that the adjudicating authority in relation to the corporate person's guarantor is NCLT, having the territorial jurisdiction where the registered office CD is located. The key observation here is mere fact that appellant is a citizen of Singapore is irrelevant for initiating proceeding against appellant, as the residence of personal guarantor is not a relevant factor. Since the registered office of CD is within the territorial jurisdiction of NCLT Kolkata, insolvency proceedings could be initiated against personal guarantor in the same tribunal. Further, the adjudication of disputes related to a personal guarantor of the court does not have any nexus to the personal guarantee's residency status. Scheme of court does not indicate that a personal guarantor shall be absolved from his liability on the pretext that he has obtained citizenship of a foreign country. Applicability of section 234 of the code arises if the assets or properties of a personal guarantor are situated outside India. In the present case, the assets of the personal guarantors were not situated outside India, and the said personal guarantor could not take refuge under section 234 and 235 of the code. The next one is Krishna Kumar Basia versus State Bank of India. What it says is application is to be, we have discussed this earlier, I think. Application is to be treated to be filed when it is filed in the Office of Registry of NCLT at the filing counter. And in case filed in electronic form, the filing is complete as soon as it is registered electronically. Which means any application under 94 or 95, either through e-filing or physical filing, the moment it's filed and registered, which means you're getting an acknowledged diary number, your application is filed. So that is the date when the interim moratorium would start. It is in relation to that. The next one is Central Bank, oh God, sorry. Central Bank of India versus Mr. Potapati Raju, and this is NCLT Amravati. The question of law here, whether notice is required to be issued to personal guarantor at the stage of appointment of RP. The NCLT held here that the notice was issued to the respondent or PG, but none appeared. Even notice from the court after it's heard first time, even if the respondent PG have appeared, no right of audience is available to them under the relevant provision of section 95 or 97. Of course, this is what is being challenged. It's one of the aspect under Article 32 and 40 that is being challenged under Gurmeet Sodhi case in Supreme Court. It is only under section 100 subsection 3 that the A shall provide a copy of the order passed under subsection to the creditor. Hence, in terms of section 97 and 100 of IBC, no right of audience can be given to the respondent at the stage before appointing the IRP. But this, till the time stays there, I don't think we can use this. But there is a judgment which says issuing of the notice once you have filed in the court application and a notice against that to the personal guarantor is not necessary if an application is filed under 95. The next case is Bank of Baroda versus Divya Jalan, NCLT, Kolkata. It says whether the financial creditor is entitled to recover dues of the corporate from the legal heirs of personal guarantor. In fact, Mr. Das also mentioned about the issue of whether the recovery can be made against legal hire or not. So the fact is the corporate debtor and the guarantor were required by agreement to repay the outstanding amount of term loan calculated bank guarantee, but they failed. As a result, the corporate debtor was declared NPA on December 31st, 2018. A petition under Section 7 was filed and CD was admitted to CRP in 2020 for an amount of 105 crores. The personal guarantor Sandeep Kumar Jalan, the notice died and the notice that was supposed to be issued to him was issued to the legal heir on August 13, 2021. Now, what are the observations? When a Section 95 application is filed, the assets of the personal guarantor is hit by moratorium. The rights of third party will be severely harmed if you put the legal heir of deceased personal guarantor in the position of personal guarantor and automatically place a moratorium on their personal asset as well. The code makes no mention of legal heir filling the shoes of deceased personal guarantor. Furthermore, the term personal guarantor is defined very clearly by the legislature. At code refers to only to the personal guarantor's estate assets. Under the code, it is not possible to maintain the current application against the personal guarantor's legal heir. As a result, clauses 21-24K of personal guarantee agreement dated so and so are in conflict with court's definition, and the petition was dismissed. This is the personal guarantee agreement between SBI and Sandeep Kumar Jalan. Sorry, Bank of Baroda and Sandeep Kumar Jalan. This one case again, Mr. Das also referred. Alchemist Asset Reconstruction versus Mr. Deepak Puri, Mozabear case, this one. Whether legal action against a deceased personal guarantor continues. The financial creditor previously filed an application under 95 of 2016, starting the insolvency resolution process against the personal guarantor of creditor, Mozabear India Limited. And the application was made through a resolution professional. The RP issued, RP inquired, and they learned that the personal guarantor of the CD had passed away in the US in October of 2021. RP stated that in case of a personal guarantor death, legal action against the PG would cease. He stated the proceeding under court are not in the nature of recovery, and thus the proceeding should not be closed upon the death of the PG. Let's see it. The principal bench observation was the law as projected by RP and the reasoning given that the PG in this case is an individual who should guarantee to the CD. Proceeding against him must be closed because proceeding will be terminated upon the death of him. In case of proceeding under 95 is a case for initiating the IRP against the PG and not a case of recovery for any amount because that would be contrary to the scheme of IBC. In such a situation, on the death of PG, an individual who is given his guarantee in favor of CD, the question of continuing the proceeding against such a dead person will not arise. Since the proceedings are over, Section 95 application must be closed as well. And application under 95 was rejected, the proceeding was closed. Next one is Iqbal versus State Bank of India, NCLT, Kochi. It says the question of law is initiation of CRP mandatory for maintainability of an application against personal guarantor under 95. The Honorable Court's observation is initiation of CRP of the CD is not a pre-requirement for maintainability of an application under Section 95 of IBC filed for initiation of insolvency resolution process against personal guarantor. So this point is very clear. We have seen in other cases discussed earlier also. The next one is Dheeraj Vadhavan versus Union of India, NCLT, Mumbai. Whether service of demand notice is a requirement of personal service in case of filing under such application under 95. This relates to the Vadhavans of DHFL. So in DHFL, Mr. Dheeraj Vadhavan had given a personal guarantee by joint deadline. A demand notice sent by Union Bank of India at his residential address, and it was received by his nephew. An application was filed under 95, but a dispute arose between the parties. Maybe a dispute is created that the application was not served on him. Here, the A held that the demand notice was served and allowed the application because the requirement under Section 95 of 14 days notice does not speak about a personal service. It can be served at the residence or it can be served at the official address of the personal guarantor. And because the NCLT held this, an appeal was made by the defendant, and this also again was dismissed. What it says is, demand notice under Rule 7.1 of 2000, which is sent by India Post and duly delivered on the said address, which is accepted by the direct member of the applicant's family. The meaning of serve as per Rule 3G means sending any communication by any means, including registered post, speed post, courier, or electronic form. The provision of 3G contemplates the situation where a document cannot be served in any mode. It shall be affixed at the outer door or some other conspicuous part of the house or building in which the addressee ordinarily resides and carries on the business or personally works for gain. In the present case, provision of Rule 3G was not resorted to since the notice dated so-and-so was sent and received. And it is then very clearly the notice of the address of the applicant is valid service and no personal service is required. The next one is Rekha Singh versus Sapur Palonji Finance Private Limited. what was the issue? Whether CRP can be initiated against an NBFC under Section 95 of the Act? Whether CRP be initiated against any personal guarantor, irrespective of CRP against corporate debtor? The observations were, see, the law provides personal guarantor, as the court elaborated upon what constituted a personal guarantor. The personal guarantor refers to an individual who is a surety to a corporate debtor or a contract of guarantee with the latter. And there has to be a contract of guarantee, and the individual has to be a guarantor to a corporate debtor. And the definition of personal guarantor under Section 522 code expresses that they can be recognized as such only if the person or entity for whom they have given guarantee is a corporate debtor. CRP or liquidation proceedings could only be initiated against an NBFC if the total size of the NBFC is 500 crores or more. So this again sets up that if there is an NBFC, the CRP proceeding against that NBFC as a guarantor or can only be proceeded against if the size of the NBFC is 500 crores or more. The basic observation in this case. Now the next case is SBI versus Ms. Balaji Sankarao Chaudhary, Mumbai. Section 9 application filed by OC against CD. The respondent here signed a deed of guarantee against loan amount from SBI. Demand notice served to respondent and personal guarantor, but no response received. SBI filed Section 95 application against personal guarantor. Whether demand notice issued against corporate debtor under Section 7(1) of code also allows for Section 95 application being filed against personal guarantor or not. Observation: in absence of any response from respondent or payment from personal guarantor is received within 14 days as stipulated by demand notice, Section 95 application may be admitted, which means a notice under Section 7, which was issued to the corporate debtor as well as to the guarantor, if no response is received or no payment is received within 14 days as stipulated in the demand notice of Section 95, then this notice is considered good and the application may be admitted. Other one is Ramesh Chandra Agrawal versus SBI. Appellant stroke the personal guarantors were provided a copy of the application, but were not given the limited notice. Subsequently, RP was appointed to submit. Issue: should personal guarantor be given limited notice to file objection under application under Section 95? So the observation, relying on the judgment of Chandresh Jadlu versus Siemens Financial Services, Honorable NCLAT held that personal guarantor should also be given a limited notice to file their objection. Additional time given to the personal guarantor in this case to file their objection, based on which the adjudicating authority may admit or reject the application. So within 3 days, the application, the copy of the application was to be given. The notice has to be given to them. This one is an NCLAT one. Pramod Kumar Mittal versus UCO Bank. The appellant personal guarantor had not filed any reply against Section 95 before the applicant preferred to file the appeal instead of replying, stating that the A order records finding of default. Issue: whether default was found before admission of Section 95 application. Observation: RP under Section 99 of the code must file a report first, on the basis of which Section 95(1) application may be admitted under Section 100. The finding of default must not be treated as acknowledgement of default, but acknowledgement of submission by the applicant. An adjudicating authority must independently consider the question of default while passing the order under Section 100 of the code. The next one is Sandeep Garg, Director, Bloom Infotech versus DMI Finance. Applicant or personal guarantor of corporate debtor. CRP was initiated against corporate debtor, or application under Section 7 was still under consideration. And simultaneously, Section 95 application was filed against personal guarantors. The issue is whether the financial creditor can invoke multiple remedies by filing claims of the same amount in some other corporate insolvency resolution process, and whether a claim still being considered in CRP of corporate debtor can also be filed against personal guarantor of corporate debtor. The observation is very clear. The law does not prohibit that. The financial creditor can initiate simultaneous proceeding against the corporate debtor as well as the personal guarantor. And we have seen in an Lalit Kumar Jain also that a personal guarantor is an independent contract. So these two are pursued. There is no prohibition in the law. The next one is Rashpal Singh Todd versus Volkswagen Finance. The issue raised here, whether the prior invocation of the arbitration proceeding against the personal guarantor bars the initiation of CRP against the company. Which means, what it says is there was an arbitration proceeding which was invoked against the personal guarantor for recovery of the guarantee amount. Now it says whether in presence of a particular proceeding going against the personal guarantor, does it bar the initiation of CRP against the company? The observation of the Honorable Tribunal was that prior initiation of arbitration proceeding against the personal guarantor by the creditor does not bar the financial creditor for subsequently filing an application under Section 7. We have seen earlier these two are parallel, these two are independent contracts, and they have to be viewed accordingly. Even 60 subsection 2 does not prohibit parallel filing. I think I'm just skipping 3 slides because this is only my way of saying that this could be treated, the insolvency proceeding could be treated as a boon or as a good thing by personal guarantors, because once they have landed into this situation, then they should use this process to get a discharge for themselves and start afresh their life than, remaining with the multiple litigation and the cases going on, because personal guarantee cases can drag on for months, years together, and then it becomes very difficult for personal guarantors to continue any business because of the orders, interim awards. Becomes difficult for them to pursue any kind of individual business or vocation. So in my personal opinion, it can be used as a good thing once they have landed into a situation where they are personal guarantors and default has happened. There is every likelihood, or there is CRP proceeding going against the corporate debtor, or since they have given guarantees and that possibility of that getting invoked is very high, then they should avoid doing any of the avoidance transaction and use this opportunity to get a discharge for themselves. I would advise anybody who came to me under the situation, and I would advise, please go through the process completely and, get yourself a discharge and start a new life. I think I'm done here. So any questions, one or two questions we can take. And
Sir, if the RP recommends, doesn't recommend for COC formation, how to go about the voting, sir, in that case?
no, sir, if you recall in my slides somewhere in the earlier part, first part, I said there is no concept of constitution of committee of creditors. So the RP does not need to constitute a committee. What he has to do is while he is verifying the claim and preparing a list of creditors, what he has to do is to arrive at the voting share, take the debt of claim admitted of a particular creditor versus the total claim admitted. All debts of the admissible debt or admitted debt of the personal guarantor. So a personal guarantor has a 1 crore of total debt against which a bank comes says 8 lakhs is my claim and 8 lakhs is admitted. Then the voting percentage of that bank would be 8% because the total debt is 1 crore and admitted debt of that particular one creditor is 8 lakhs. So that's how the, and when you list.
No, my question is whether a meeting has to be conducted for taking the voting, because it has to be voted by 75% for the resolution.
Yes, for the repayment plan, yes, sir. The meeting concept of constitution of committee of creditors is not there, which means you don't have to constitute and file that. But once you have done the list of creditors, you have to submit that list to the A, and you can call for a meeting. And in that meeting, voting has to happen because the notice of the meeting has to very clearly give time, venue, etc., including the issues to be discussed and issues to be voted upon. And in case if all the creditors do not vote, then you may have to arrange for electronic voting. But in case of repayment plan, it clearly says 75% of the voting share of creditors present and voting. Did I clarify your question, sir?
Yeah. What you mean to say is the constitution of committee is not required, but for voting purpose, we have to conduct a meeting.
Yeah, committee's meeting has to happen. Committees, he can call any number of meetings to ensure, including the one for the repayment plan.
Okay. One more doubt is why this the rationale behind this two-step process, sir? One admission under section 95 and again admission under section 100.
See, if you ask my personal opinion, I think this is right. And the logic, according to whatever little I've understood or what I read in the committee's report, etc. See, in an individual insolvency process, two steps are necessary. One is giving an opportunity to reorganize, restructure its assets and debt and be able to repay and get a discharge at that stage. If that repayment does not happen, then taking all, because at this stage, all the assets, etc., is in the custody of the personal guarantor. The RP does not take custody. RP only helps him or very clearly defined what role RP has to play in running the business or maintenance of the existing business. RP does not run the business for him until unless it is decided by the committee as well as the personal guarantor. Whereas in bankruptcy, the assets are moved to a estate and the estate is managed by the trustee. The debtor does not have any say there. And management of that is to, liquidate the estate and pay. The estate is distributed between the creditors. So it is important to give an opportunity and then demarcate that where no opportunity can be given, then it passes on to a court-appointed officer. That's my take, sir.
No, my question is not for insolvency and bankruptcy. My
Mhm.
question is initial admission of application by the adjudicating authority and appointment of an RP, and after submission of an IRP report under section 99, again admitting the application under section 100. Why these steps are required? It can
Good question, sir. It didn't come to my mind, but as you've asked, I think maybe the legislation has been done to expedite the process because court has to verify a couple of things. One is the existence of debt, existence of default, evidence of non-payment, or existence of not payment of default. So if an RP has been asked to comply the requirement of 94, 95 and then report with his recommendation whether to be admitted or not to be admitted, it's possibly to help and expedite the process, help the court and expedite the process where a court, where a regulated professional has been asked to do the verification and then submit a report. And the court can take a quick, if they feel satisfied, they can take a view. If they don't, they can call for additional evidence, etc., and then reassert and then admit. That's my view.
Okay, sir. Thanks a lot.
I think it's been a long day. If there are no questions, then let's call it and close this. Yeah, please.
Sir, good evening, sir.
Good evening, sir. Please tell.
Sir, this question pertains to a corporate debtor, where the corporate debtor has taken loans for unsecured loans from the financial institutions like NBFCs. So now, what is the role of the personal guarantor? How he will be liable to the creditors, the NBFC banks? These are all unsecured loans.
No, I'm just trying to understand. The corporate debtor has taken a loan from NBFC.
Exactly, sir.
And that loan has been guaranteed by whom?
By the directors or partners of the firm.
So it doesn't matter whether it's bank or NBFC. It's a lending institution. NBFC recognized, even otherwise, if money has been given by somebody in an agreement and it's money has been lent, to against, interest or time value of money. I'll go to 5.8 definition of a financial debtor. So if that lender by the agreement can be classified as a financial debtor, financial creditor, 5.8, 1, 2, 3. So if that be the case, okay, they can initiate, they can file against, they can initiate section 7 application against the corporate debtor, they can initiate this thing. So NBFC is a licensed entity of RBI. It's a lending agency. It can, even in absence of that, a financial creditor can always take a section 7 application there.
So it can proceed against the personal guarantor also.
Yes, yes. Simultaneously.
One thing you have not, I think, should have mentioned is there is no distinction between OCs and FCs in personal guarantee.
Yeah, there is no, okay, you're right, you're right.
Good, so thanks a lot for a nice session and informative. The judgment part was really excellent, actually. Thanks a lot.
Thank you very much.
Any further questions? Sir, I think we can conclude now.
Thank you so much.
Thank you so much on the behalf of entire team, and very sorry for the inconvenience caused in between.
No, that's, I'm good. Thank you, participants. Thank you. Ma'am, please take care.
Take care, sir. Also, to all the participants, I would request while filing their CP applications on the portal, kindly submit the CP mailer as the documentary proof, because I've seen most of the applications have the flyer. Then it gets a little difficult. We have to check the entire record and then we have to grant the CP. So I would request, it would be great if you could just post the CP mailer which you received on the mail. Just take the screenshot of that mail and post it, upload it. So it will become comparatively little easy because we are receiving a lot of CP applications by the end of this month. So that's from my end, and thank you so much, everyone.
Madam, will you give that participant certificate, because I am from ICAI.
Sir, so we do, as of now, so we do not issue a certificate. We are in the process of getting it done. We have spoken to our seniors regarding this, and we would need some time. But as of now, we will be sending the CP mailer on the registered email ID that you have used while registration. So you may please check that email ID by the end of the day today, or maybe tomorrow morning. The CP mailer will be circulated with all the participants.
Madam, also ensure that these presentations are sent.
Yes, sir, I have actually, we mail it just after the session. We mail it to all the faculties and speakers who come. So we just wait for them to send it and then we'll share it to all of them. All right. Thank you so much, everyone. Have a good
Thank you, madam.
Thank you.
Thank you.